Okay, so it's 10 o'clock on Thursday, the 14th of March. Welcome to this hearing session on planning and energy policy. Today's session forms part of the public inquiry into the application by Scottish Power Renewables UK Limited for consent under Section 36 of the Electricity Act 1989 and deemed planning permission to construct and operate the proposed Earraghail renewable energy development on land between Tarbert and Skipness on the Kintyre Peninsula. The DPA reference for the case is WIN-130-8. My name is Tammy Swift-Adams. I'm a reporter and I'm joined by Karen Hayward, Assistant Chief Reporter. We both work for the Scottish Government Planning and Environmental Appeals Division, or DPEA. We've been appointed by the Scottish Ministers to prepare a report setting out our recommendations on whether or not the proposed development ought to be approved. Our colleague David Spears is also with us behind the scenes for technical support. I'd like to take introductions now from the people who are going to participate in the planning and energy policy session, which we're starting off with this morning. As you introduce yourselves to each person, each individual person could just say a quick hello. That'll help us test that your mics are working before we get started. So I'll start for the applicant with you, Mr. Innes, if you could just introduce yourself and the people participating.
Yes, thank you, Madam. Good morning. My name is Colin Innes. I'm a solicitor with the firm of Shepherd Wedderburn, and up here this morning on behalf of Scottish Power Renewables, the applicant. In terms of the vast majority of responses to the matters on the agenda, it will be Alison Sidgwick, Director of Onshore Consenting and Environment at Natural Power, who will be assisting you. I have a couple of areas which I will be coming in on, but they will be relatively few in number and restricted. So with that introduction, I'm just going to hand straight over. I'm with Alison here in the same meeting room. We are on a single framework, so we can't speak over each other. So I'll now hand over to Alison and we'll test that the system transfers seamlessly.
Good morning, everyone. Hopefully that's working.
That was indeed seamless. So thank you very much. Thank you very much. Mr. O'Carroll, could you do the same for yourselves and the council, please?
Certainly, ma'am. Good morning. I'm Maurice O'Carroll. I'm an advocate with the Scottish Bar and a barrister with the English Bar. I'm representing the council today for this hearing session, and I'm accompanied by two planning officers from the council, Mark Lodge and Arlie Knox.
Good morning.
Morning.
Good morning.
Good morning. I'm Mark Lodge, one of the Senior Planning and Strategies Officer at Cambria Council.
Okay, thank you. Yeah, I can hear all of you fine then. And Mr. Gregg, could you do the same for yourselves and Nature Scott, please?
Yes, good morning, ma'am. My name is Cameron Gregg. I'm a solicitor at the firm of Morton Fraser Roberts. I'm joined by my colleague David Forrester, who's in the room with me here, and Nature Scott. Witness for this session is Mr. Simon Brooks, who is the Strategic Planning Manager at Nature Scott. I'm also joined by David Davison of Nature Scott as well, and we'll be using a room audio system, which will hopefully pick us both up when we speak, although Mr. Brooks is the witness for the session.
Okay, I got a little bit of feedback when I was listening to you, so it's maybe because of that room audio. I tried to mute myself, but that didn't make a difference. I could still hear you, but if when we come to the evidence, we're struggling to hear, we might have to just ask IT to have give us a bit of quick advice on that. That might could improve.
I think that might be it.
Yeah, my apologies. Good morning, everyone. Simon Brooks here. I think there might be just a problem with my laptop in that I'm still getting feed out the laptop when it's switched off.
We'll look into that, ma'am, and hopefully
okay. That might disappear as we go along. Okay. Okay. Thank you very much. Put my mic back on. Okay, so we're hoping to complete this session and also the conditions hearing session, both within the day today. We've got tomorrow blocked out in case we run over, but based on the agendas, I think we should be fine for today. I gave quite a lot of introductory and housekeeping remarks when I opened the public inquiry formally last week. of the comments I've made. There's just a few that I need to reiterate for the session today. Firstly, just as usual, I'll make sure that we take short breaks as we move through the agenda at sensible points, and we'll break for an hour at lunchtime, unless we're finished or about finished then. Please mute yourselves when you're not speaking, but make sure you've got your mic on when you are. If you're just observing today, please keep your cameras off, and if you're participating, keep them on. That just reminds me who I'm expecting to hear from through the day, and if there's any hands raised, I'll be able to see those. Please raise either your real or virtual hands if you need to attract my attention at any point. It's not my best skill to see people immediately, but I'll do my best, and I've got Miss Hayward with me as well. He'll keep an eye out too. Use of communication devices is fine, but if you are using a mobile or laptop, etc., please just keep it on silent so that it won't interrupt the discussion. And I've confidently written down we're not expecting a fire alarm here today. I think I'm right on that. So apologies if I'm proven wrong. We've circulated an agenda in advance, so hopefully you've all seen and got that and had a chance to look at the questions that we're going to run through to frame our discussion. Does anybody have any questions before we begin? Okay.
Just one point from me, ma'am, if that's all right.
Yeah.
Well, 2 points perhaps. Is that better on the audio side of things?
Yeah.
Perfect. And the second point is not directly relevant to the session, but there was an email from the case officer earlier this week inviting comments on the new local development plan and on the Narracon decision within 14 days. And I was just wondering if there might be something to be said for wrapping up those comments and those submissions as part of the closing submissions that are being prepared by parties. So I just suggest that as to avoid a separate stage of procedure, if that would be of interest.
I think timescale wise, that would just mean a bit longer for the Narracon and LDP comments, wouldn't it? Because the dates that we initially set for the closing statements from parties are in early April. Is that? Yeah, I don't think that causes a problem. So if it's easier for people to wrap that up together, I'm happy for people to do that and revert to doing that within the overall closing statements in line with the dates that are in the PM. Mr. Innes.
Thank you, Madam. Just in terms of Narracon, it was certainly our intention to make sure that you had the full information that was available before the reporter and ultimately the Scottish ministers in relation to the matter. And therefore, we would have been lodging those, and then parties would have had another chance to respond. One of the issues that putting it into the closing submissions is concerned is that effectively our position will come at the end and parties wouldn't be given an opportunity to respond to that matter. So I note that the close proximity of matters, but I do suspect that actually that might be an element of problem in respect of that matter, because effectively you've issued a procedure notice allowing us to respond, and I think part of that response could say, for example, you should see the report that was prepared and that formed the basis of the recommendation that was made, and why certain findings might have been made by the Scottish ministers. And I think that means that would be helpful if that were in before other parties closing submissions. So I'm perfectly comfortable keeping to that sort of 2-week deadline. And then if parties want to have an opportunity to respond and closing submission, they can do so. But I just flagged that as I could see an unfairness looming in the process, whereby effectively we would end up with a never-ending of more submissions after closing submissions. So as I say, in respect of that matter, I would be happy to keep our position to lodging our position in 2 weeks' time. If other parties want to comment, then fine. But I think that would better keep your timetable than if I were to say, well, let's just wait to the closing submission for us to put all that additional material in. It's not a lot, but some additional material in. So as I say, I'm quite happy for the applicant to have to meet that 2-week period. And then if the other parties want to comment, that they can do so in their closing submission, which we then get a right to respond to effectively in the closing submissions on behalf of the applicant.
Thank you. I think that's a helpful point you made. Mr. O'Carroll, you want to comment as well?
I think I can go one better. So Mr. Gregg says closing submissions, Mr. Innes says within 2 weeks. I suggested I would like to go even closer than that. Firstly, I suggested it might be an idea just to have those formally included as core documents today. And by my view of the core documents list, that would mean the decision would come at core document 872 and the report would be at 873 if you're amenable to doing that. And the reason why I say that is because it strikes me that it would be helpful, at least in passing, to make mention of the Narracon decision and the report associated with it today for both sessions, because it may be relevant to them. And therefore, to leave it for 2 weeks or even into closing mean that we didn't have the opportunity to discuss it today when it is relevant. So I would suggest that we were unable to do that today.
Okay, so I'm just going to put my mic and camera off for a second, write down a coherent note, and then tell you all what it says about how we're going to proceed with that. It won't be very long. Okay, hello again. Yeah, so basically a combination of what everybody said there is fine. We'll use those core document numbers that Mr. O'Carroll mentioned, CD008-072 for the Narracon decision, CD008-073 for the Narracon report. Happy for people to refer to those documents today. Obviously, we do still want the written submissions on them, and we're happy with Mr. Innes' suggestion that if the applicant can provide their submission on that within the 14 days of the email, as we'd first set out, other parties can then provide their comments in their closing submissions, and that will all be fine. Okay, thank you very much for that suggestion. Are there any other questions or comments before we move on through the agenda? Okay, then I'll move on to agenda item 2, which relates to statements of agreed matters on the energy and planning policy framework. So the applicant submitted a statement of agreed matters on energy and planning policy, which was agreed with the council. There's two-part question on this. The first is, to what extent have planning and energy matters been agreed with Nature Scott and other parties? And then we'll come on to whether there are elements of the other statements of agreed matters that are particularly pertinent to this session. So could I maybe start with the applicant and then Nature Scott on the first part of the question, Mr. Innes?
Thank you very much. Yes, as you say, there was agreement with Earraghail and Bute Council and the applicant in respect of planning and policy matters. No attempt was made to reach an agreement with the local community group in the context of the topics. Thinking about Nature Scott, there were some elements in that. So, for example, at section 3.9 of the Statement of Agreed Matters on Landscape and Visual, MPF 4 comes in, but no greater attempt than that was made.
Thank you. And Mr. Greggs or Mr. Brooks, that corresponds with your understanding where you are?
Yeah, yes, we're as been stated, we're not a party to the statement on green matters on policy. We don't have any particular issues with anything in that statement either. Perhaps we would note that paragraph 4.6.6, where it talks about the key policies, we would reflect that policy 1 probably merits being a key policy for consideration. And also we would note that at paragraph 4.7.1, where there is reference to one of our documents, an S&H document, as we were then, spatial planning for onshore wind turbines guidance, is to bear in mind that was produced to support Scottish Planning Policy 2014, as was, and therefore we think that would be given limited consideration or limited, much reduced relevance today. And then on the other statement of agreed matters on landscape and visual matters, yes, correct, it does refer to MPF4, but I don't think that adds anything of consequence to what is covered in our policy and planning hearing statement.
Okay, thanks very much. Does anybody else want to comment on that agenda item before we move on? It seems quite straightforward. Okay, so agenda item 3 relates to the onshore wind policy statement 2022, which is court document 005019. Do parties agree that the onshore wind policy statement indicates a clear policy ambition for increased deployment of onshore wind energy, in particular in the period to 2030? It's probably easiest if anybody raises hands if they don't agree with that statement and want to comment. Okay. So the second part of this question is, to what extent, if any, is it appropriate for decision makers to give consideration to the need case in the context of an individual proposal? I'll start with the council on that. Mr. Lodge or Ms. Knox.
Sorry, I was just trying to unmute myself. The Renewable Energy Policy and Emissions Reduction legislative framework underpins what can be termed a need case for renewable energy. It's considered by the Council that the need case derived from this framework is embedded in national and local policies, and it will therefore be considered in the policy assessment of the proposal and will be given appropriate weight according to your assessment of the evidence.
Okay, thank you very much for that. Ms. Sedgwick, do you have anything to add on that?
Yes, in terms of the need case, I think it's important to look at the need case for the national development category into which the proposed development falls, which is National Development 3, and it's covered on page 103 of, which is Annex B of MPF 4, which is CD.
Sorry to interrupt you. We do have to take notes of what you're saying here, so I appreciate if you could go a bit slower, please.
Apologies. So I think looking at the statement of need for this particular national development that's set out in MPF 4, and you'll find that on page 103 of CD reference 006001. And that sets the needs case, which is the requirement for additional electricity generation from renewables and electricity transmission of a scale that is fundamental to achieving a net zero economy and supports improved network resilience in rural and island areas. And then it goes on to talk about island transmission connections, which aren't relevant in this case. And my view is that it's clearly very appropriate for the decision maker to take the needs case into account as part of their decision making process. I think the other thing I would add is that the needs case as it's set out in the OWPS is government policy. It's not purely planning policy, and the needs case and the aspirations for targets of 2030 again is something that should carry significant weight in the decision making process.
Thank you. And for Nature Scott, Mr. Brooks, is there anything you want to add on that topic? And I should add, everybody doesn't always have to comment on every topic. They won't all necessarily be relevant. That's probably particular to you, but you may comment if you wish.
I will just keep it short. No, we do agree that it is relevant to take into account the need case.
Thank you very much. And I see overside on my agenda, I do have a point C on this topic, which is what are the implications of the suspensive condition requiring aircraft detection lighting systems and the potential delay in implementation that could cause on the contribution the wind farm may make to the 2030 target. I'll start with the applicant on that, please.
Yeah, thank you, Madam. Perhaps putting in context first, the 2030 target set out in the onshore wind policy statement is a minimum of 20 gigawatts installed by 2030. The timing of that commitment also is aligned with the target of the 75 reduction in emissions to be found in the 2009 climate legislation. So therefore, the one is related to the other, and the other is related to setting out a clear target for a particular type of generation. In that context, therefore, it also ties into policy 11 of MPF4, which aligns the ultimate balancing decision in 11 in the contribution that the proposal makes to renewable energy generation targets and greenhouse gas emissions. And in relation to onshore wind in Scotland, we currently have a renewable energy generation target for that particular technology by a particular time frame. Against that background, the 2030 date is important in that there are clear targets on decision makers and also a wider public policy objective to achieve this particular objective. Now I turn to deal with the implications that has in the context of dealing with ADLS. The first point to note is that this project currently has a grid connection date of 2029. And that effectively is the target date against which the development of this project is being designed against. One factor prior to being able to operate in 2029 would, as far as the applicant's concerned, be resolving the ADLS issue. And in that context, I don't want to repeat at length the evidence that was given at the landscape and visual session, but in essence, Mr. Van Hoostreiten's was demonstrated that effectively to implement the ADLS, there were two component parts of the process. The first was the approval of the ADLS, which would be governed under the Air Navigation Order, Article 222, ability of the CAA to permit variations to the lighting requirements. And as we've seen in terms of numerous inquiries, you have understood the ability to derogate from the harsh standard of having to fully light the turbines all the time. And we've seen movement to reducing lighting intensity and also potentially reducing numbers. These are all decisions that are made by the CAA under that provision and essentially reduce the obligations and thereby also reduce effects. In terms of the evidence, Scottish Power Renewables have already submitted a trial to the CAA to test the technology. The CAA have accepted the test for trial, and the relevant equipment, which is a technology which already exists, has already been fitted to the Mark Hill wind farm, which is an operational wind farm in the southwest of Scotland. In terms of the final piece of the jigsaw before the trial actually starts, is the transponder zone over the trial area we need to obtain certain data from that and submit that to the CAA to allow the baseline situation to be available prior to the trial starting. The evidence suggests, very strongly suggests, that the trial is very imminent and that it would take some 6 months to complete in terms of collation of the operational data in the field. There would then be a relatively short period of another 3 months to analyse that data and submit it to the CAA. That would eventually deal with the first part of a Navigation Order 222, the acknowledgement and acceptance of the technology working and allowing the CAA to permit this type of technology to be deployed. The second part of the successful deployment of ADLS requires a mandatory transponder zone over the area in question. The first point to note is that Scottish Power have already advanced discussions with the CAA over an application for a permanent transponder zone in the southwest of Scotland. They've been through the initial process of what's involved in that matter, including discussions with various aviation interests in the locality to understand any concerns that they may have. Again, at this point in time, there's no indication of there being any significant issues arising for aviation interests arising from that. And in terms of this vicinity, again, the team from Scottish Power have analysed the general aviation situation over the wind farm and do not foresee that there are any particular aviation issues about promoting a mandatory transponder zone over this airspace. In terms of the process, it requires an application for airspace change, and that is a process which is currently governed by a process set out in CAP 1616, which is essentially the CAA setting out how they go about the process. And as we learned last week, that process under CAP 1616 is currently being changed in terms of being updated to reflect updated directions issued to the CAA by the relevant Secretary of State for Transport. And I'm not going into the detail of the changes at the moment, but as highlighted last week, these changes are substantive in the sense that they are providing much clearer guidance about airspace change. And when you get the opportunity to read the documents, you'll see that this relates to airspace modernisation, which is a policy agenda which the government has been driving and which ultimately is being reflected in the way in which the CAA operate and also manage airspace change. I think, as I say, without prejudging you having the opportunity to review the documentation, effectively what government is saying is that we're anticipating a greater necessity for airspace change to reflect our various policy objectives relating to the management of airspace in the UK. Within that process, the CAA have been mandated to effectively revise and improve the systems under which they operate, and in particular, a key response as being a proportionate response to the particular airspace change that is being promoted. And I think it's relatively easy if you read the documents to see that they're trying to categorise the various airspace changes. And for example, if I am changing routing of large volumes of aviation over major cities, that is something which is considered a particularly important airspace change because it may have environmental impacts on local communities in terms of noise. That's a matter which will need to be investigated, properly evaluated and reported upon, and ultimately in terms of the regime. If there's a particular controversy, the Secretary of State can call in those types of decision for determination. And then that's the higher scale of airspace change. And then it moves down in terms of various categories of airspace change to ones which effectively unlikely to have any large scale impact on aviation movements or operations. And they are given essentially a streamlined process. So you will see there that the airspace modernisation is already in train. The rules are changing, and effectively we are moving to a different system that is probably more effective at delivering the second part of the process, which is required. We also heard evidence that at the current time, i.e. under the old rules, the assumption was an airspace change could take up to 2 years. My final point in relation to mandatory transponder zones is that in document 01033, we already utilise mandatory transponder zones in order to facilitate offshore wind farms in Scottish airspace, effectively that which is where the offshore wind farm applications are determined by the Scottish ministers. And in those circumstances, if it is that element that is supposedly too uncertain to predict, then it would be wholly inconsistent of the Scottish ministers wearing one hat offshore to require potentially this mitigation and then say it wouldn't be available onshore, because there's no evidence to support that inconsistency of approach. So against the timing of evidence, it is anticipated that in the next 12 months, the issue of the ability to fit ADSL will be a matter which will be resolved, and that easily within the following 2 years, a mandatory transponder zone application can be made and dealt with. Against that background, based on this evidence, this project can commence and will be able to deliver energy in 2029, and that this particular discharge can be conducted within the timescale set out. Now, I don't want at this stage to prejudge my response either to the Earraghail decision, but suffice to say, what I can say is that I have reviewed the evidence submitted on behalf of the applicant in relation to that particular application, and it is different from the evidence that we have submitted here. And I think if one reads any of these decisions, it is clear that the Scottish Minister's decision-making is based on evidence. And as they said it in Earraghail at paragraph 119, the Scottish ministers have carefully considered the option of imposing a suspensive condition to secure the installation of ADLS prior to construction of the proposed development, but do not find that the evidence provided to date in the matter affords sufficient assurance that either method would be capable of being installed on the proposed development within the next 5 years. We will submit the evidence that was given, and on the basis of the evidence that was submitted by the Earraghail applicant, that's a conclusion that is relatively easily to be made, because that is the position that they were making, that they shouldn't be forced to fit the technology, because they were arguing that the regulatory regime hadn't been resolved and therefore there was uncertainty. But that arises from not going through a process as we have done in working with the CAA, nor do I think it is an accurate reflection of the stages that are required to go through in order to deliver the technology. As I say, that's roughly the best I can do in terms of the material that we have at the moment, but I will obviously be responding in some detail to the Narracan decision, and in our response to the Narracan decision, I will also reference the relevant aspects of the updated CAA document 1616 that I hope will be lodged before you, and which would reflect the current position of the CAA on dealing with airspace change.
Can I just clarify, Mr. Innes, that there were some documents lodged this morning and circulated this morning. Are these the documents you're talking about?
Yes, I am, Madam.
Yeah.
And I'm not going to, as I say, that's why I don't think it's fair for me today to make a detailed description of those. I think the right point to do that would be in response to Narracan on that updated information, and then other parties will have the full opportunity to respond to that in light of that. And I was mindful of not doing that this morning because I don't think that is either fair or appropriate. I think it's a better process where it is in writing and the parties get a proper opportunity to respond.
Thank you very much. So in terms of the basic question about the implications the suspensive condition of that nature could have in the contribution this wind farm could make up to 2030, you don't think there's an impediment to that for the reasons that you've set out. So I'll just move across and see, does the applicant have any comment that they were, sorry, Council, I'm sort of in my mind, I'm looking at you, Ms. Knox, but I'm saying the wrong thing. Do you have anything to add on that?
Yes, please. The Council's take on the evidence at the LVIA inquiry last week was that, firstly, the approval of ADLS is in the hands of a third party over which the applicant has no direct control. And secondly, there is still some doubt regarding the actual likely date of approval of ADLS. So there's no definitive date for sign-off. Therefore, if there is a suspensive condition relating to ADLS, the timescales for the delivery of the project are uncertain, and the contribution that it might make to meet the 2030 targets can't be quantified. In light of the evidence provided at the LVIA inquiry and the very recent Narracan decision, where Scottish ministers rejected a suspensive ADLS condition, the Council is now questioning the feasibility of such a condition. And I understand that this may be discussed at the conditions hearing. Thank you.
Okay, thank you very much. And would Nature's Scott like to add anything on this point?
I don't think, Mr. Brooks, and correct me if I'm wrong, but I don't think Nature's Scott have anything to add beyond noting that suspensive condition wasn't considered appropriate in the Cochrane and Narracan. Mr. Brooks, do you have anything to add from?
Nothing to add.
Can I just clarify, Mr. Innes, in relation to that statement you made earlier about, so there's a suspensive condition saying there's no construction can take place until the ADLS has been sorted out, essentially. Are you talking about 3 years for that to be sorted out? And then, then you start on the site. So there's not very long to go till you get to 2030, is there, if you're starting at the site in 3 years' time?
Yeah, but if I could respond, the point is how one goes about this is not unusual. And just responding to Ms. Knox's point, it is absolutely standard in aviation mitigation terms to go through a process of testing mitigation. And quite frankly, it only gets final sign-off from the CAA right at the end. So this idea that somehow all aviation matters are sorted out up front, they're not. They have to go through a process. And if you're making a change, a safety case has to be made and approved by the CAA. So in terms of any of those conditions, a third party will always have an element of having to vet and approve what is put forward. In essence, it's a basis of, if we go back to the Scottish Government guidance on aviation radar, what the advice was, and there was a genuine concern about what would happen in aviation conditions and whether they could be discharged. What they were talking about was whether the technology would be available within the next 5 years, because that was what we were talking about, technology that had never been tested, that had never been tried, that we were having to deliver. And the history of onshore wind in Scotland is inextricably tied up with resolving these issues. And you just look at Whiteley. Whiteley was the first to effectively have to resolve radar issues. Nobody had done it before. And effectively, it required the third part. They had to build radars to provide blanking and coverage. So they had to get a planning application. Then the operation of the blanked radar had to ultimately be approved by the CA. Equally similarly, that was also applied to the Clyde wind farm. At that time, there was no solution other than potentially building another radar within central Scotland to provide that cover. And in terms of all those matters, yes, they were delivered. And I think one of the points I just want to make is the fact that this project has a grid connection date to 2029, the fact that we have Scottish Government targets for onshore wind and climate change objectives in terms of 75% reduction provides the justification to allow a ADLS system to be fitted, because effectively we need to justify why we are doing it. And that is the reason why other adjustments have been made to aviation, is essentially to facilitate the policy objectives of also trying to respond to climate change. So actually it's very helpful in terms of justifying the process to have these requirements for this technology and the levels of deployment required by a timescale, because it also provides, when we get to the airspace change justification, the reasoning for it. But as I say, in terms of the process, I can't see, if the Scottish Government are prepared to consent offshore wind farms with the requirement of a mandatory transponder zone, why there should be any difference in terms of an onshore scheme also requiring it. Because it equally has to go through the process of requiring to effectively go through an airspace change. It too has a construction programme, and it too generally gets 5 years as a consent timescale. So in terms of past history, these matters are generally resolved, and the timing works because effectively there is a gap between us and our grid connection date, which is in effect, if decision on this application would be taken towards the end of this year or beginning of next, it is a 5-year time period that would be probably applicable, because that's the standard that's applied. And the timings do work. And equally, the timings work for us in terms of having to go through a process of promoting an airspace change, because effectively it will match roughly the timescale of when we need to commence development to meet the 2029 grid connection date. So, okay, so as I say, we wouldn't be suggesting a condition that we couldn't meet, because otherwise there would be no point in having a consent. And equally, any project wants to build as close to the grid connection date as you can, because that's the date by which effectively you can commence the construction and make ultimately the return on the investment that's being made. So we all want to deliver on our grid connection dates as quickly as possible, because that's the whole purpose of the project.
Thank you. I was just going to ask a clarification question, which is, are grid connection dates for projects which involve a form of airspace change process, are they typically met, or are they as typically met as a grid connection date with one that doesn't have an issue?
And I think you've opened a can of worms discussing grid connection dates, but as a general rule, they don't. It is a challenge, but generally speaking, they move depending on what. I mean, there is obviously ongoing dialogue between the developer and the the connection agreement coming about actually what can be delivered within timescales, because obviously you've got the infrastructure that has to be committed to in terms of grid as well. But they roughly match often the timescales for construction periods of the wind farm. That's usually the timings. So they're effectively being coordinated to make sure that once the turbines are erected, they can then operate. And so there is that very direct relationship between the two. And no, the objective is not ever to leave sitting turbines because it's not good for them. So the grid connection and the project development are inextricably linked. And there is ongoing dialogue to make sure that that happens and it works together.
Okay. Well, I won't pursue a can of worms any further if anybody doesn't have any comments to make. We can move on to agenda item 4 if people are happy.
If I could just make another comment though, with regard to that, and I apologise if I'm going to run over all ground, but what Mr. Innes has done is provide quite a lengthy, detailed summation of the evidence that we heard last week at the inquiry at the LVI session. And I think it'd be fair to say that what he said today is considerably more coherent than what we heard last week. And you recollect that in the course of that discussion with Mr. Hoogstraten and his evidence, I did query, I just simply asked what I thought was a fairly straightforward question, is that when can all this be done? And of course I did presage that question with the observation, the obvious observation, that there are many elements of this that are within the hands of third parties over which the applicants have no control. And you recollect that he wasn't terribly willing to provide me with any such likely completion date or likely sign-off, as I put it, which is a term he balked at. But that's really what I was getting to. In all fairness to him, I was simply trying to get to a point at which, in relation to this, there's a substantive issue here, and then there's the issue related here in terms of the 2030 targets. But it does touch on a substantive issue as to whether consent can be granted at all in the light of the Narracon decision. But what happened then last week was that I took things as far as I could, which I have to say was unsatisfactory. And then you, ma'am, Ms. Hayward, then clarified yet further. And then in re-examination, Mr. Innes then took further evidence with regards to that and then set out the two-stage process, which he's now set out in advance, set out in greater detail today. But so what it does seem to be, though, is that firstly, whatever the Scottish ministers might do consistently or inconsistently with offshore wind is neither here nor there. It's a matter of aircraft safety, and that the body that's responsible for that is the Civil Aviation Authority. Civil Aviation Authority will not sign off on a scheme unless it's entirely satisfied that it's going to be safe. It must do so by virtue of testing and on data. And we had evidence with regard to the length of time the data would be. It varied between 12 months and 6 months. And then there was also then, as we heard in re-examination, the second stage, which is the mandatory transponder zone. Now, that was a matter that was also touched on in the Narracon decision about whether or not, or whether it's feasible that you would then have all aircraft then fitted with the necessary transponders to comply with that requirement for ADLS to work. That is a system-wide consideration that requires to be applied and can't simply be done at the stroke of a pen or the waving of any kind of a ministerial wand. So it does seem to me that, and I'll touch on this later perhaps, but in terms of the original question, in terms of the 2030 deadline, which are acknowledged, that there is still sufficient doubt and uncertainty, even standing Mr. Hoogstraten's evidence, given that the elements that I've just touched on very lightly at the moment, that does call into question, A, the question of whether or not the 2030 contribution can be made in terms of OWPS and also NPF4, but also then it goes further than that, as I've stated.
Mr. Innes.
Yeah, just responding on a couple of the matters raised. The first point to note about timings and dates is that Mr. Van Hoostretten was told in no uncertain terms before giving evidence that the evidence that was before us was CAP 1616, which is in the documentation, and hence why when cross-examined and asked subsequently in chief in re-examination about the timings, he put the 2-year time period in for their airspace change, because that is, under the old rules, roughly the timescales that would have prevailed, up to 2 years. So I think, to be fair, and as I say, I'll leave you to review CAP 1616 and the changes made, but it wasn't thought fair to introduce a whole lot of evidence last week when the documents hadn't been lodged and other parties hadn't seen it. And I have to say, I think that would have confused matters. So he gave his evidence on the documents, but did advise that there were changes in place because of the directions that have been implicated, and some had yet to come into force, and those are documents that are subsequently submitted. In terms of a decision, Mr. Earraghail seems to suggest that CAA will have to take some blanket decision on ADLS. That's not accurate. What the CAA will in the future potentially have to do is determine whether within their powers under the Air Navigation Order 222, whether it will be appropriate for a derogation to be approved in that circumstance. And I just pause to observe that this is one of the things that probably differentiates our evidence from some of the others, because what they have portrayed ADLS as is something that effectively the CAA will just provide a blanket solution to. But our evidence and the evidence of Mr. Van Hoostretten is that at this stage of the process, it will be approving individual schemes, and they'll have to determine whether it's suitable in the particular circumstances of the particular proposal in question. There may, at a future date, be a wider change in airspace regulation, which may mandate the requirements for all planes to be fitted with EC. Again, those might well create circumstances of a total change that then might result in wider regulation, because of that change in itself would be a change to the whole management of airspace. But that's not the basis of the evidence that we've put forward, nor is it the basis on which we rely. Our evidence is solely based on the existing regulatory framework, which we have analysed and we consider has the ability to deliver both the framework for an individual scheme ADLS. And all that will do is approve that technology for that scheme in that area. It will do nothing more or nothing less. And the point about this is that there are already areas in Scottish airspace where the CAA, because of airspace change, have made them zones where transponders of a specification require to be carried by aviation traversing into those locations. So that is already happening, and it's already taking place. So again, that's not new, that already exists. So as I say, I think there are subtleties there in the way in which this is being presented, but we're very clear in what we have presented, which is a very specific case based on the current regulatory framework and the decision making. And I think it is important to note that I totally consider that the matter that the Scottish ministers have to answer is how they draw distinctions between transponder zones in offshore schemes which have been necessary to discharge conditions and onshore. Now, I don't know whether the onshore consents unit are aware that their colleagues offshore have essentially been doing this. They may not have been given an evidence before, but we were very clear that when we lodged that material about those orders that have been pronounced, to give the examples. They are there, they're in place, and you can see from the geographic locations and the references that they relate to wind farm development. And I think it is a very important distinction because they would have to rationally discriminate between that type of order and one that's required here. And I just don't, on the face of it, see that is justified. So, as I don't really want to add further, otherwise I'm going to be duplicating submissions I've already made. But I did want to just pick up on a few matters that Mr. Earraghail had raised. Thank you.
Thank you very much. So, have we finished on that point, or are there any further layers? No. Okay, I'll move on to agenda item 4. And question A under agenda item 4 is hopefully a straightforward one. It's whether parties agree that NPF 4, which is CD 006001, needs to be read and applied as a whole, with factors for and against a development to be weighed against one another. Is there anybody who doesn't agree with that point? Okay, I'll move on to B. With reference to the National Spatial Strategy in NPF 4, how should the reporters interpret references to, or the reference to, the right development in the right place in the context of net zero commitments? And I will ask the council to start on that, please.
Thank you, ma'am. The National Spatial Strategy, while supportive of net zero commitments, still requires us to ensure that the right development happens in the right place. It requires us to adapt to the impacts of climate change whilst protecting, recovering and restoring our environment. Individual proposals still require careful assessment and the balancing of issues. There will be changes to the environment, but they should still be in the right place. It does not mean development at any cost, which has been reinforced most recently by the Sheerdrum and Narrachan decisions. Thank you, ma'am.
And the applicant, please.
Thank you. Right development, right place has always been a very difficult question to answer and things, and I think it's something that many planners over the years have tried to grapple with and things. I think for me it's very clear in policy 11B of NPF 4 that the wrong places for onshore wind are national parks and NSAs, and that in all other locations the place may be right, but as Ms Knox has said, that's not a guaranteed will be right. You have to look at all the various policies, you have to read the document as a whole, you have to consider the various criteria and come to a decision. Is a particular proposed development in the right place for that particular proposed development? And that could be residential development in an urban area, it could be a wind farm in a rural area. And to my mind, you have to think about all the different elements that go into consideration of location and come to a conclusion as to whether or not it is the right development in the right place. And from that point of view, I don't think there's much more you can do on that.
Thank you. And would Nature Scott like to add anything on this?
Yes, I mean, I would pick up on the point that the council made, that I think this is a reminder about, it's not development at any cost. We all recognise there is a very strong imperative of addressing the climate crisis. No one's denying that. But we don't want to be in a position where, I guess you could say, where in the past, where we've made mistakes about ignoring or not giving adequate consideration to other interests. And I think this is, or attempted to be summarised at the front of NPF 4 on page 4, where they talk about that rather than compromise or trade-offs between environmental, social and economic objectives. This is an integrated strategy to bring together cross-cutting priorities and achieve sustainable development. And that's the ambition that runs through NPF4, I would suggest. And NatureScot recognises that wind farms in general are clearly recognised as being the right form of development, with all the policy support that sits behind that. But we still need to consider whether this particular wind farm is the right development in its expression of location, siting and design, in reaching that, taking that view, which I think planners probably do on a day-to-day basis, about thinking whether this is the right development in the right place.
Okay, are there any further or follow-up comments on that before I move on to C? No. Okay, so C, the question C is, what implications does national development status have for the proposal? Do parties agree it provides support in principle? Can I start with the applicant, please?
I think the easy answer to that is yes, it does provide support in principle, but it's a qualified support.
Thank you. And does the council agree with that?
Yes, the council would agree with that.
Thank you. And anything different from NatureScot on that point?
No, we'd agree with that.
Very much. So section D of agenda item 4 relates to NPF4 policy 11 on energy. So to start with, does the proposal maximise net economic impacts with reference to criterion C? I'll start with the applicant, please.
Again, it's another slightly tricky question here. There is, as various reporters and the ministers have advised in recent decisions, that there isn't a standard set of guidance. It's very difficult to say A, B and C has been done and therefore it is clearly demonstrated. But I think what we have to do is think about what this development could do in terms of net economic impact. The environmental statement report at chapter 15 talks about the work that the applicant has undertaken to date in Earraghail. It references £2 million have been awarded to community benefit funding coming from energy projects in Earraghail and Bute. And it talks about some of the various community initiatives, if you like, that have benefited from economic input as a result of the Ben and Turk schemes, and it talks about refurbishment and costs and running costs for the Campbelltown Picture House. It talks about support to the Kintyre Way. It talks about contributions towards a community dialysis unit and that kind of thing. So this development is a substantial development. It would attract significant community benefit as a result of that. And I think it's really important to look at the examples that the applicant has got across the country in ways in which they have maximised community benefit and have maximised socioeconomic impact in that context. It also talks about the local procurement services that they've used in Earraghail and Bute, and it talks about the type of local services that could gain employment or gain work through the proposed development. And that ranges from things including forestry services, site and ground investigations, plant and equipment hire and things. The other thing is looking at it at a slightly higher level, is thinking about the role in which the applicant has played in the sector deal. The sector deal is an important document, and it's CD reference 005002, and Scottish Power were a signatory to that on behalf of the industry. And that document is looking at supply chain initiatives, and it's looking at the important role that onshore renewables, onshore wind, can have in the context of the economy of Scotland.
Okay, thank you very much. And can I take the council's thoughts on this point, please?
It's the view of the Council that employment during the construction, operational and decommissioning phases has the potential to bring minor positive economic benefits, and that the proposal goes as far as it can in terms of maximising net economic impact. In respect to community benefit, I would just like to highlight that that's not something that we would have any control over. So it's not usually taken into account in our determination of the application.
Okay, so I just asked the applicant on that one, the evidence, the section of the EIA report that you're talking about there, does that give a clear distinguishment between the inherent, I guess, economic benefits of the development, the types that we would take into account in planning, and the separate community benefit payments?
Yes, it does. It talks about there's the sort of community benefit side of it, and then it talks about procurement and employment and that kind of thing separately.
Okay. Thank you. Is this something that Nature Scott wants to say anything on?
No, we have no comment on this section.
Okay, thank you very much. So the second bullet under Part D relates to North Arran National Scenic Area. Do parties agree that the proposal impacts on a national designation, that being the North Arran National Scenic Area, and therefore requires to be assessed in relation to Policy 4, Criterion D? I'll start with you this time then, Nature Scott.
Thank you. Yes, we agree, and the rest, in terms of the evidence you would have heard last week from Ms Anderson, we consider Policy 4C is the key policy for considering the impacts on the NSA, and that's reflecting that Policy 11D directs, it's very clear, it's a direction that you need to consider it under Policy 4 in general, but within Policy 4, Policy 4A, we think, is still relevant, but in effect, its issues are covered by Policy 4C. And I won't get into the details of Policy 4E on the precautionary principles. I know that's covered later.
Okay, thank you very much. Can I come to the applicant now on this question?
Yes, we would agree. There's a clear signpost in Policy 11D in respect of indirect impacts on national designations, and an NSA is a national designation.
Okay, and thank you, and the council?
Yes, we would also agree. Thank you, ma'am.
Thank you very much. So moving on to the next bullet, in Criterion E of this policy, how should the reporters understand the requirement that project design and mitigation will demonstrate how the following impacts are addressed? I will start with the applicant, please.
Thank you, Mark. I'm going to take this one, and I think it's important to understand that whilst policies need to be read as a whole, they also have a correct legal interpretation. And in this context, paragraph E in my submission is very clear. What it's saying is project design and mitigation are matters which are expressly dealt with as the requirement of the EIA process. And effectively, what this requires is for us as the applicant to explain what we've done in terms of project design and what we've done in mitigation relative to a list of topic matters that the Scottish Government particularly want to be informed of in relation to determining this type of application. And I think it's pretty important to understand that that is what is being requested. In terms of a test, it is not a development management test. It's about information gathering as to what an applicant has or has not done in relation to specific topics and in relation to how the project's been designed. And I suppose fundamentally, what it's saying to applicants is these are all matters that we're going to take into account. So when you're considering the project formulation, we expect you to have addressed these matters and to properly evaluated how you've come to the conclusions of the project you've come to, having regard to these matters. And in terms of the output of that, it will be what's the project design chapter, thereafter the individual steps that have been taken to mitigate the likely significant effects from rising from the project, and that will be then left with the residual effects, and those will effectively be the impacts which will be found under each of the topic numbers. Those then get taken into the exercise which comes at the end of the list, which is, in considering these impacts, significant weight will be placed in the contribution proposal to renewable targets. So what we need from the shopping list is what are the impacts that then have to be tested against effectively the benefits. And I think the trouble is there's sometimes a bit of a temptation to say, well, if the project's got into difficulty on heritage, then I must have failed the passage on heritage being a consideration that's got to be considered. Well, actually, there's nothing in the list, the shopping list, that talks about a development management test. And I'll come to Roman numeral 2 before we come to it, but I'll just put my proposition there. So I don't think it is correct to find that any effect fails the shopping list. What it is a consideration that's found at the end of the process of project design and mitigation. That's an impact that gets taken into the overall consideration at the end. And Roman numeral 2, which deals with landscape and visual impacts, is one which obviously tends to be the focus, given the nature of the projects that we're dealing with. But what it's saying is that's one of the issues. The significant landscape and visual impacts are an issue. So that's the shopping list. I want to understand the significant landscape and visual impacts, recognising that such impacts are to be expected for some forms of renewable energy. And I would say I put onshore wind definitely into that category, insofar as I don't think I've ever dealt with an onshore wind farm of scale, which does not give rise to significant landscape and visual impacts. The second part of it is phrased in the positive. So where impacts are localised and or appropriate design mitigation has been applied, they would generally be considered acceptable. And I think, again, that's phrased in the positive. If it had been turned round and said that we're only going to consent.
Sorry to interrupt you, Mr. Innes. I'm now going on to the next bullet point.
Yes.
So perhaps
I was going to. Do you want me to hold fire?
Yes, I know people respond to what you first say.
Okay. And then so we'll come to that specific one next. But as I say, that's our position on the interpretation of policy E, and I'll come to the second part on when we come to consider it. But we'll probably do a double act on that because I deal with the first bit and Sidgwick deals with the substance of it. Thank you.
Okay, thank you. So can I take the applicant's thoughts on this matter?
Council.
The council. I'm thinking in my head. I'll try not to do it again. The council, please.
It's the council's view that this requires a proposal to be designed and mitigated to a degree where any potential impacts are either avoided, minimised or mitigated to an acceptable level. The expert advice of the council's landscape architect is that effective LVIA mitigation is not possible with the current design. The outstanding aviation objections from NATS and Glasgow Prestwick Airport have yet to be resolved, and suitable mitigation is yet to be agreed. And also, the recent Narrachan decision sheds significant doubt regarding a suspensive ADLS condition as a way of mitigating nighttime LVIA effects. Thank you, ma'am.
Thank you very much. And Nature Scott, would you like to comment on this, please?
We've got nothing to add.
Okay. Then I'll move on to that next point, which is how should the reporters understand the terms localised impacts and appropriate design mitigation in the context of criterion E2, and what implications does this criterion have in this case? So I will hand back again to you, Mr. Innes or Mr. Sidgwick.
Yeah. Yes, I'm going to deal with the first general principle point, and the difficulty with that interpretation that the Council has of Policy 11E is it's not what the words say. You're having to import words about acceptability into a policy which intrinsically has as its thrust a balance at the end, and effectively it would negate the balancing exercise at the end. And as I say, I don't think the words are there to make that judgment. In terms of Roman numeral 2, we dealt with the significant landscape and visual impacts, i.e. that's a matter that's in play. We're looking to demonstrate project design and mitigation. It then goes on to say that where they are localised and or appropriate design mitigation has been applied, they would generally can be considered acceptable. That's phrased in the acceptability positive sense. It does not mean that where effects are not localised, that you fail some test. Whatever is the residual impact that arises from the significant landscape and visual impacts requires to be taken into the overall balancing under 11E. That's the requirement. In terms of the detail of this, I'm now going to hand over to Alison, who's going to respond to the detail of the matter.
Thank you very much. Yeah, so I think in this one, it's not clear that there is any definition of localised. Various reporters have looked at it in the context of various situations, and they've reached different conclusions. In some cases, they have found that the effects are localised, and they've then gone on to conclude that in this context, it's acceptable. There are also situations such as the Shepherd's Rig situation where the reporters found more than localised effects, but they still found, on balance, that proposed development to be acceptable. So, as Mr. Innes has said, just because a development has more than localised impacts does not mean that consent cannot be granted. You have to look at the wider picture. You have to look at the balance in that context. In terms of thinking about the design and the mitigation for the proposed development, my reading of Ms. Carol Anderson's LVIA document for Earraghail and Bute, which is CD 011006, is that the design and layout generally achieves a cohesive appearance. And she makes that statement in paragraph 4.3. And she makes a similar statement in paragraph 3.3 of her report for Nature Scott. And to my mind, my understanding of that is that the development, the mitigation, the design mitigation that has gone on in this context is appropriate.
Okay, can I ask for the council's view on what's been said, or any other comments that you've got on this point?
Thank you, ma'am. We'd agree that the MPF4 provides no definition of what constitutes localised impacts. At the LBIA inquiry last week, Kelly Anderson accepted that a multifactorial consideration is required in terms of the host landscape and the severity of impacts, so that geographical impact alone is too simplistic a measure. The Forsyth decision may also be of assistance in this regard, where the reporter states that the applicant's main use of distance to determine localised impacts to be too simplistic. He then provides useful bullet points on all the other factors that he considered in this regard. The council's view is set out in Carol Anderson's inquiry report. In terms of appropriate design mitigation, it's not considered that this proposal has been the subject of appropriate design mitigation. And once again, I would refer to Carol Anderson's advice in this regard. Thank you, ma'am.
Okay, thank you very much. Would Nature Scott like to say anything on this?
No, we wouldn't. The understanding or definition of localite isn't a primary concern for our case.
Okay, thank you very much. So the next bullet point, I'll try and get to the end of the bullet points on this part, and then we might have a short break. The next bullet point on this list is in the context of the last paragraph of criterion E, is the availability or otherwise of grid capacity a relevant consideration in this case? Mr. Innes, your hand is up.
Yeah, I just want to come back on the council's point, which I think fails to distinguish between the effects and appropriate design and mitigation. The ES chapter sets out a whole framework of how effects and design has been set out, and in particular, landscape and visual effects were considered very carefully. Now, in terms of the proposal, at no point did Ms. Anderson, on behalf of the council, criticise effectively the design. She was not suggesting that there was inappropriate design, or that, for example, that effectively anything else could be done. I think the line she adopted on behalf of things, there's nothing that could be done in terms of this scheme which could make it better. And the point about that is that that's the point, is that the scheme was designed to ensure that where it was visible, which is primarily to the east, that it set a coherent design. And that is exactly how Ms. Anderson, on behalf of the council, described the project. So insofar as the two matters of the project design and mitigation, insofar as the developer could achieve those objectives, they've done so. There's a separate issue, because the issue is what comes next, is what's the residual effects. And I fully accept that in terms of carrying out a process, you can achieve the best project design and mitigation on a site, but it will give rise to effects that then have to be considered in the balance as to whether or not they're acceptable or not. But in terms of the design at the site, that was not a matter which was subject to criticism. And I do emphasise that it's only that aspect. I fully accept that Ms. Anderson, on behalf of the council, raised issues about the impacts that derive from the final design, and they obviously will have to be carried through into the decision-making process and the balances, whether under policy 4 or 11.
If I could just chime in there as well, please. It's one thing to talk about the coherence of the disposition of the turbines, but there's a really fundamental point, is that part of the design is that they're 180 meters high. So that's a design feature which is quite clearly mentioned by Carol Anderson and forms the mainstay of her statement and her objection on behalf of the council. So I wouldn't like it to remain in the minds of the reporters that Carol Anderson gave a green light to this particular proposal in terms of its design and the mitigation that's been applied, given what in fact is in fact proposed.
Okay. Thank you both for giving your thoughts on that. Is there anything else before I move on to the next bullet? No. Okay, I'll just read it out again because I was a bit premature last time. In the context of the last paragraph of criterion E, is the availability or otherwise of grid capacity a relevant consideration in this case? I'll start with the applicant, please.
Thank you. There is grid capacity, as we've heard already, at 2029, and so that fits with meeting targets of 2030, and the applicant in this case has sort of worked out how they align the application process, the decision-making process, the development process to then hit that grid target. I think the other thing is that we need to be aware of the fact that MPF4 in itself doesn't set the targets and things. They come from the Climate Change and the Emissions Reductions Act and the OWPS and things. So in that context, we have to think about the grid capacity and the ability to hit those targets, but you have to look at both sets of documents.
Okay, and just to clarify, in terms of the specific wording of the question, in your view, is the availability of grid capacity a relevant consideration?
It's relevant because the answer to the question is there is no constraint there.
Okay. Can I take the council's answer on this one, please?
The council considers that the availability or otherwise of grid capacity is not considered a relevant consideration in this case. The policy is quite clear on this matter. Grid capacity should not constrain renewable energy development. It is for the developers to agree connections to the grid with the relevant network operator. Thank you, ma'am.
Thank you very much. Does Nature Scotland? Oh, I'll let you come back in, Mr. Innes.
Yeah, again, if we're reading policies as a whole, the paragraph above the section says grid capacity should not constrain renewable development. Then specifically states that in considering these impacts, significant weight will be placed on the contribution of the proposal to renewable energy generation targets. Whereas the generation targets 2030, that then becomes a relevant consideration. And I think you've got to remember that MPF4, the generation target might vary because it's set by government in an energy target context. It's not a planning target, it's an energy target. This is an example where policy 11 recognises that effectively the demand side of the equation is being set externally because it talks about renewable energy generation targets. And some technologies have them and others don't. But where there is one that has both a scale and a temporal dimension to it, then clearly meeting a 2030 target is a relevant question to ask. It wouldn't be a ground for refusing a proposal, but it has added weight if a proposal can assist meeting that renewable energy target, because otherwise it would be reliant only on effectively supporting greenhouse gas emissions at a future date. And we do know that the 2030 target's not a cap. So effectively, the government's asking, give me as much as you can by 2030. But we want to achieve at least a minimum of 20. So therefore, there is a temporal dimension to the renewable energy target that's been set.
Okay. Is the council wanting to come back on that at all? No.
Sorry, no, ma'am. Thank you.
No, that's okay. And Nature Scott, did you want to add anything on that?
No, we have nothing to add on this question.
So our final bullet under section D is the applicant highlights that policy 11 does not refer to tourism, unlike the former Scottish planning policy. What, if anything, should the reporters take from this? And I'll start with Ms. Sidgwick, please. The applicant.
Yeah, I think in looking at the removal, if you like, of tourism from the SPP list, my assumption is that the Scottish ministers have clearly decided that the evidence is very clear that tourism doesn't have an impact, that onshore wind and renewables don't have an impact on tourism, and that it's a non-issue, and therefore they've removed it from that list. To the best of my knowledge, there's no literature that says there are adverse impacts on tourism as a result of onshore wind, and I'm not aware of any literature saying that there's been an impact on Earraghail or on Arran as a result of onshore wind affecting tourism.
Thank you very much. Could I take the council's thoughts on this, please?
Thank you, ma'am. I'll try and answer this one. It's recognised that NPF4 doesn't specifically relate to tourism under criteria in Policy 11, but the criteria in Policy 11 continues to include reference to landscape and visual impacts, public access, including long-distance walking and cycling routes, and scenic routes, as well as impacts on the historic environment. It's considered that in the context of Earraghail and Bute, these factors make a considerable contribution to the attraction of the area to tourists, and therefore NPF4 covers those impacts. I'd also point out that LDP 2, Policy 30 on sustainable growth of renewables, still requires the assessment of impacts on tourism and recreation, and that should be given some weight, given it forms part of the development plan, along with NPF4. Thank you.
Thank you. I've got a follow-up question on this, which is if there was a particular aspect of tourism or a tourism facility that might be impacted by a proposed development of this nature, would the wider policy content of NPF4, there's the LDP as well, but within NPF4 itself, is there scope or a hook for consideration of that?
Yeah, I mean, I think that the
Sorry,
wider, sorry, ma'am. I think that the wider policy context in terms of NPF4, requiring all the policies to be looked at, would take into account the effects on tourism. Tourism is not a particularly defined thing. It applies across the whole of the economy, and the things which are attractive in Earraghail and Bute to tourists are covered by other criteria in policies in NPF4.
Thank you, and Ms. Sidgwick.
I think if there was an impact, for example, on one of the long distance routes or whatever, as Mr. Lodge has said, that would be covered by other parts of the criteria set out in Policy 11, in Part E of that. And I think in an assessment that would be undertaken as part of the EIA approach, if there was a particularly sensitive tourism facility nearby a onshore wind farm, then that is something that would be considered. Okay. But I'm not aware of any such facilities in and around this proposed development.
Okay.
Sorry, just to interject there, what about the holiday park at the entrance?
Yes, but I think that's something that quite often in the context of onshore renewables, it's not that uncommon to have caravan parks, campsites or whatever that are in and around onshore wind farms. And I'm not aware of any evidence that such accommodation facilities are adversely or positively impacted by the presence of the wind turbines there. In the context of just thinking about the sort of economic benefit, sometimes these places can benefit during the construction process when they're used for accommodation.
Thank you. And I think in the EIIR, there's obviously reference to the fact that the access route for construction phase would come in from the existing route through that holiday park, and that there had been some discussions. I don't think it says specifically that that's definitely the case. Is there anything more known about discussions with the holiday park or how it'd be used since that was written?
Can I take instructions at the break and then I'll get back to you on that? I don't want to do anything other than give you the best position on that.
That's
So
okay. That's okay.
I'll take instructions. Thank you.
It's a specific thing that's not on the agenda, so that's fine. I'll take. Does anybody else want to comment on this question of tourism policy, or shall we take a break now and resume? No. Okay, so I'll go for a break now, and let's come back at 5 to 12 at 11:55. Okay, thank you very much. So before we move on to our 4E on the agenda, sorry, 4D, I'll just come back to you, Mr. Innes, and see whether you found any update on the discussions with the holiday park.
Thank you, Madam. Yes, the owners of the Tarbert Holiday Park have been parties that the applicants have spoken to over an extensive period of time. If the project were to proceed, it is likely that they would be financially involved. And in that context, the holiday park has not objected to the proposal, and indeed sees opportunities arising from it. The accommodation that's provided there is quite varied. There is the opportunity for people to come with caravans or motorhomes, but there are also existing glamping pods and static caravans. They also have a centralised facility. What that does provide is they've got quite a lot of flexibility as to where accommodation sits within the site. And against that background, they are positively disposed at this stage in terms of all the discussions that have been held to date. And that's about as far as I can take it at this point before it would be inappropriate to say anything further. So I think that's the position. They don't object. They have been in discussions from an early stage of the process. They are likely to be financially involved if the project proceeds, and they've not objected.
Okay, thank you very much for that clarification. Mr. Lodgeville, you wanted to come in on this point relating to the holiday park.
Thank you, ma'am. Yes, please, if you don't mind. I should have directed you to NPF 4 Policy 30, which relates to tourism, specifically in relation to the holiday park impacts. Part C requires development proposals that involve a change of use to tourism-related facility to only be supported where it can be demonstrated it's no longer viable and there's no requirement for alternative tourism-related facilities in the area. So if the tourism facility at the holiday park is to be used to provide workers accommodation or provide access to the site, some judgment will have to be made as to whether a change of use has taken place and as to whether that would be supported by NPF Policy 4, NPF 4 Policy 30. Thank you, ma'am.
Okay, thank you for that reference. I'll let the applicant note that, because it's not the proposal. There's not that change of use proposal before us, but we can note that there's a tourism reference there. Okay, so I'm going to move on to agenda item 4D now, which is NPF 4 Policy 1 on tackling the climate and nature crises. This is an opportunity for parties to give us any thoughts they might have on how we might attach relative weight to the climate crisis and the nature crisis that are referenced in that policy. And I'm going to start with the applicant, please.
Thank you very much. I think that they need to be considered as equal. They need to be considered as not being mutually exclusive. And this is particularly evidenced in my mind in the cross-cutting outcome and policy links section on reducing greenhouse gas emissions in NPF 4, where it talks about the global climate emergency and the nature crisis have formed the foundations for spatial strategy as a whole. The regional priorities share opportunities and challenges for reducing emissions and adapting to the long-term impacts of climate change in a way which protects and enhances our natural environment. And this is reiterated in the improving biodiversity cross-cutting outcome as well. And in my mind, many of the documents that we have inextricably link the two, and we need to think very carefully about climate change and be getting that right. Otherwise, there is the real risk that the nature crisis continues to spiral and gets to a point where it's not recoverable and things. So we have to be very careful in thinking about them. We have to weigh them both in the balance, and I think they both should attract significant weight in that balance.
Thank you very much. And can I pass to Nature Scott now, please?
Thank you. Yeah, I'd agree with the tenor of that. The policy doesn't distinguish between the climate and nature crises, and Nature Scott, as I think the Scottish Government does, consider them very much as twin crises. They're very much related. So we expect both to be addressed together and at the same time. I also agree that policy one should be given significant weight in the determination of this. So obviously, the actual final weight is a matter for yourself and the Minister.
Thank you. And the Council, please.
Yes, I would agree that both the nature crisis and the climate crisis should be given equal weight, and balance be given to those by the decision maker in weighing up the negatives and positives and negatives of each of the proposals. Thank you.
Thank you very much. Any final comments on this part of the agenda? I will move on to 4E, which relates to policy 3 on biodiversity. The applicant considers that the proposals go beyond mitigation and will restore and enhance biodiversity. Do parties agree? I'll start with Nature Scott, please.
Thank you. I think in a general sense, we accept that the proposal and what's set out in the draft habitat management plan is going to deliver enhancement. But I think it's what lies underneath in the detail that needs to be considered and given further consideration. I think this is where we start to differ, in that the statements are not always clear. So the issues I would raise is one about additionality. I think that whilst there are statements in the hearing and planning policy statement that everything is additional, I think that's contradicted by statements in the biodiversity submission from the applicants. And I'd refer you to paragraphs 24, where it recognises that the native woodland, heathland proposals and the new native woodland creation are already specified within the land management plan. And I think that runs counter to the intent of additionality that is set out in the Scottish Government's draft planning guidance on biodiversity. That's reference CD 418, where additionality is the last of the 8 core principles set out in that document. The second issue I would raise is needs to be given consideration is about the timescale for peatland enhancement. And I think the applicant has confirmed in their biodiversity submission that the timescales indicated in Nature Scott's biodiversity submission are accurate based on the current timescale of the woodland management plan. In addition, I would also like to note that that's a timescale for undertaking the action or restoration. So if you like, getting the machinery on site, restoring the peatland habitat. It then takes time for the habitat itself to become restored. I'm not an ecologist, so I'm not going to offer evidence on how long it will take. And I do acknowledge that there is a range of views around specialists on this. And this is one topic that we are working with the industry on and is reflected and recognised in the onshore wind sector deal. So there's ongoing work about that recognises we need to be clearer about the timescale from doing the action of restoration through to when you get or achieve a habitat of good condition, functioning in habitat. The third element, and you may want to delay this until later, but I also note that the applicant is asserting that the biodiversity benefits or enhancements being undertaken is of national importance. And this is relevant when we come to the consideration of policy 4C. NatureScope do not believe that the proposals they are setting out are considered of national importance. And I'm not aware within the documentation that I've reviewed where the thinking rationale to provide the justification for that is set out. These matters of detail we think are important that the reporters have a clear view on, because this comes into the weight in particular that's given to the nature crisis in terms of policy 1, but also if you are minded to accept the applicant's arguments about the biodiversity enhancement being of national importance, then this will come into the consideration of policy 4C too. Thank you.
Thank you. Okay, so I'm going to go to the council now and then give you a chance, applicant, to come in and address the two parties' comments at the end. So, council, please.
Thank you, ma'am. I think the council would defer to the expert advice of NatureScope in this regard.
Okay.
Thank you.
Fine. Okay, so over to the applicant, please.
Thank you very much. There's one issue I just wanted to clear up, and it relates to biodiversity. So I feel that this might be the place to do it, following on from the community hearing session last Tuesday. And it relates to the width of the access track, particularly as it goes through the wooded areas. The information is set out on this in a couple of documents, but the easiest one to look at is CD 02201, which is the applicant's response to the, no, it's not, it's the additional information which was submitted in November 2023. And at 3.3.2 of that, we see reference to the fact that the existing track is typically between 3 metres and 4.5 metres wide, and that the access track for the proposed development would be a 4.5 metre wide running width with shoulders of 0.5 metres on the verges. The survey work which has been undertaken in respect of the trees in this general location has gone for a 20 metre wide buffer on either side of the track, and that is in order to inform the developers or the applicant of the nature of the woodland in that area and the characteristics of it, and it will also inform the detailed design of the track should consent be granted. There is no intention of having a 40 metre wide track or felling of a 40 metre wide swathe. That is purely the survey area. And if one looks at 002071, which is the applicant's response to the Woodland Trust, at paragraph 15 of that, it's advised that only T51, which is a tree, is likely to require removal. And that there's a photograph of that tree shown. And the tree doesn't appear to have any obvious veteran features such as extensive decay or hollowing. So it was just to provide, we wanted to just provide some clarity on that following some of the discussion on Tuesday evening. So turning to the biodiversity proposals, the additionality, first of all, thinking about it, there is an extensive area which would be subject of peatland restoration, and that is indicated on the various figures in the EIA, and that's considered to be a substantial area over and above what would be done as part of mitigation, and we say that is an important matter to be considered in the balance. I too am not an ecologist. I'm not able to comment on the length of time that peatland takes to restore. But I think it's important to note that the applicant in this case has some quite extensive experience of peatland and bog restorations, in particular thinking about their sites at Whiteley and Blacklaw, where they have successfully managed and are improving the peat and boglands in those particular areas. So this is something that the applicant understands and has experience at. And in terms of the national importance of it, my thinking there is that this is these enhancements are not being done in isolation. They're not islands. They are closely in close proximity to SSSI and SAC, and which are national designations in themselves and European designations. And that they have the potential to improve and enhance a wider picture as well.
Just going back to the policy for intent, I think one of the really important things about policy 4, as it's currently formulated, it very much encourages trying to make the difference at the site level. Now, in the context of the current site, we have that opportunity in the sense of there are already areas designated in proximity. And the real issue here is that in providing a comprehensive habitat management plan, that it is more valuable than the piecemeal approach. And while some elements might have been provided in a longer term forest plan, the difference here is it's going to be developed as a formal HMP over a much wider area, and will therefore be subject to all the monitoring and results process that an HMP comes with. That is more likely to achieve the objectives of a highly successful restoration and also planting scheme. The second key aspect of this is that we have to recognise that we are within a working forest, and it does essentially require us to also balance those interests, because it wouldn't be in the public interest to necessarily harvest early growing timber crops. And what we have done in terms of the management regime is to work through the cropping cycle and thereby identify the areas that we have identified that are particularly suitable for incorporation in the HMP. And that clearly is ensuring that those interests are properly balanced. But at the same time, the objective of the HMP has always been to create the right restoration in the right place for the long term, to ensure that it properly can connect into the habitats which are of importance and are adjacent to the proposals. Against that background, it is that comprehensive nature of the HMP and its linkages that have been at the heart of the proposals, rather than what might be portrayed as a short-term attempt to meet metrics. That has not been the objective from the HMP from the outset. The objectives of the HMP have their genesis prior to the publication of NPF4. It was to create a meaningful habitat management plan that dealt with the land uses in the long term and sought to create the best conditions long term that we could create on this site, having regard to the various interests. And that was what's driven. And as I say, the applicant could have driven itself to a more purely arithmetical figures, but this has always been about where it's going to be done, how it's going to be done, to achieve the long-term linkages that create those habitats. And in terms of part of the argument about the national importance, is it goes to the scale of the carbon-rich soils of peatland that we're restoring, and the relationships to other peatlands that has that real potential to create a much larger area of habitat and to create it in a manner which both supports and potentially extends that habitat that is already nationally designated. I mean, if we were having that effect on that scale of peatland resource, I'm pretty sure we'd be having a very different response from some of the consultees because of the policies relating to such soils contained in Policy 5. So Policy 5 essentially gives us importance, and we've really translated that back into saying, well, what can we do at this site to do the best habitat management plan? And that's really driven the whole approach to taking the long-term change to create the right habitat management plan for this location. Thank you.
Okay, thank you. And Nature Scott, would you like to say anything in response to what you've heard then?
Just for clarity, if I can, please. On the additionality aspect, the applicant referred to the peatland area. I think I accept that the peatland is additional. It's the other elements of the HMP proposal that I would question additionality. Whilst we obviously welcome a more strategic approach in terms of the habitat management plan approach, this is what is really accepted good practice across renewable developments of this nature. There's nothing unusual with that. And then also, just for clarity, the last reference in terms of the peatland restoration to carbon, we would separate that out. We're talking about restoration for biodiversity interests under Policy 3, not for carbon. You will, in simple terms, by re-wetting peatland, you are doing something good for carbon, and you'll get that benefit almost immediately. If you're trying to restore peatland for its biodiversity interest, it needs to become more of a functioning ecosystem, and that doesn't happen immediately. And that's where the debate comes in about the timescale. Is it 10 to 15 years, which some are suggesting, or is it over 30 years? And that's relevant when we're thinking about, we're dealing with a twin crises here. So it's critical that we address the nature crises as quickly as we can. The nature crisis also has targets of stopping further degradation by 2030 and moving into restoration by 2045. That's government policy there. So the delay in response to wider woodland forestry management issues needs to be considered in that context.
Thank you very much. Are you able to give me the reference for that, the relevant Scottish Government policy document with those biodiversity targets? If not,
I don't have it to hand. It's the Scottish Biodiversity Strategy. I don't have that reference in front of me, but one of my colleagues might.
I'm just wondering if it's a core document.
It is a core document.
Yeah.
Can I check, Mr. Brooks, is that Scottish Biodiversity Strategy to 2045?
Yes,
you're referring to tackling the nature emergency in Scotland. That's core document 527. Thank you.
Thank you very much. Thank you very much for that. Okay, are there any other comments people want to make in relation to Policy 3 and biodiversity? Then I will move on to 4F in relation to Policy 4, natural places. Nature Scott refers to the applicant's planning statement addendum stating that it appears to suggest that the satisfaction of policy 4C Roman numeral 2 is the unavoidable consequence simply of the recognition of a development as a national development. It's a question for the applicant. Do you agree with that interpretation of what you've said in the statement?
That's certainly not what was meant by that statement, and I think a better word would have been capable rather than able in the statement itself. So saying that national developments are capable of demonstrating rather than able.
Okay, and Nature Scott, do you have anything to say in response?
No, welcome that clarification. Thank you.
Okay, thank you. Okay, and we've got some further questions on the agenda on this point. In the applicant's hearing statement at 7123, there's consideration that part Roman numeral 1 policy 4C is either a pass or fail, and that part Roman numeral 2 requires a balance to be struck. Both of these are stated to be matters for the decision maker. Do you agree? I'll start again with Nature Scott, please.
Thank you. Certainly agree that these are matters for the decision maker. I think I would characterise, though, both limbs of policy 4C as being pass or fail tests. I think the distinction perhaps that the applicant's trying to get at is that the second limb requires some balancing in terms of reaching this conclusion on whether something clearly outweighs the effects that have been identified. And I would stress here we're talking about clearly outweighed, because in the applicant's policy hearing statement in section 7.1.2.3, there's only reference to outweigh, not clearly outweigh. And we shouldn't lose sight of that. So there is a margin that is being looked at by ministers in setting this policy. So as I said, I think both limbs are pass or fail tests. If the benefits, in terms of the second limb, if the benefits of national importance do not clearly outweigh any significant adverse effects on the qualities, the test is failed. I accept, though, it does still need to apply judgment in assessing clearly outweighed, but I don't draw any distinction between that and the judgment that is applied to the first limb of policy 4C when making a judgment on whether that limb has been, in that test, whether it's been compromised. Thank you.
Okay, thank you very much. And the council, you in agreement with Nature Scott on that thinking?
Yes, ma'am. Thank you.
Okay, would the applicant like to come back in on that at all?
No, I don't think so. I completely agree. The text says clearly outweighs, and that applies there.
Okay, thank you.
Sorry, Mr. Innes.
Yeah, I just want to make one point of difference. I think there is that in policy C1, we have the objectives of designation and the overall integrity of the area will not be compromised. We've made submission in terms of this process that we believe the objectives of designation are those set out in 263A of the Country Planning Act 1997. And in that context, under subparagraph 2, the objectives are effectively setting the scene for safeguarding and enhancing its character or appearance in the exercise with respect to any land in that area of any powers under the Planning Acts. So that sets, as far as we're concerned, the objectives. And I do pause to observe that within the Nature Scott document 06 006-012, which is a policy, draft policy statement, under paragraph 4, the reference to the legislation applying within is not really given any priority. But having said that, what I don't say is that consideration of the overall integrity would be so restricted, because that would have potentially involved wider issues. So all I'm saying is that in that first part of the test, the objectives of designation, I say on a matter of construction and law, is the objectives of the statutory designation process, but it is perfectly permissible once an asset has been designated for policy to come in and extend wider considerations to consideration of a particular asset. And that's what I say comes in here. Equally, I'm perfectly prepared to accept that the first part of that test in 1 is that both need to be passed to succeed in meeting the being supported. So if you fail the, if you don't fail the objectives of designation because you're not within the NSA, but fail the overall integrity, then you wouldn't pass subparagraph 1. You've got to meet both those requirements of matters not being compromised. And the other general point of construction that I raise here is that in the context of policy, where words are used, but in a different context, it should be construed that that is generally deliberate. So in the context of this policy C1, we see the concept of the overall integrity being used. And where we deal with local landscape designations or local designations under D1, it's just an adverse effect on integrity. And in my submission, where a policymaker is using these terms in the same policy, but using differentiations, then they should really be looking for there is a difference here, because otherwise they'd use the same language. And that I think is quite important in the overall interpretation, because it may well be said that overall integrity is setting the threshold to fail at a lower level than perhaps integrity as a whole further down. And that essentially means that a lesser effect on a national asset would compromise overall integrity, whereas on a local asset, it's got to be a higher threshold and integrity. And I think that's a general point. So I just wanted to clarify to make sure that our position is very clear on that. And in real terms, I'm not so sure on the evidence and the difference in evidence, it makes that much of a difference. But I do think we need to get this interpretation potentially right. And it's not an easy interpretation. And I recognise the wrestling that Nature Scott have done in their policy paper with trying to reconcile how this essentially operates. And effectively, because you've got these two tests under 1 and 2, they've got to make sense together, or otherwise an over forensic analysis of 1 and trying to reach a conclusion without understanding the consequence for 2 might run a very difficult overall interpretation of the policy in regard to the policy intent and outcomes. So I recognise that that's a part of all this, and I don't think we fundamentally disagree with some of the sentiment of the policy interpretation that's been set out. But what we do think is there is a bit of finer detail that needs to go into that analysis to make sure that you're not falling into an error of interpretation, given what's actually said in the paper and how national scenic areas are created.
Thank you. Would Nature Scott like to add anything, having listened to that?
Nothing further to add, thank you.
If I could come in just briefly, obviously a few points arising from what Mr. Innes is saying there, and the reporters will note there's obviously a difference of interpretation between the applicant's position on what objectives of designation mean and what Nature Scots' position on that is. Nature Scots' position on that is set out in their hearing statement, paragraph 31. I would agree that both of those tests of objectives of designation, overall integrity, they need to be met. So I agree with Mr. Innes on that point. I think there is large agreement between parties on circumstances in which overall integrity can be compromised, and that was covered last week in terms of small number of special landscape qualities of a national scenic area being impacted, or a relatively small extent of a national scenic area being impacted. They can both, in the right circumstances, be found to compromise the overall integrity of the NSA. There is a point that I would like to raise at some point during this session regarding the approach that the applicant's taken to the policy test at 4C Part 1. I'm happy to do that as part of this discussion on policy 4, or whenever later in the agenda would suit the reporters.
Okay. I think I'm happy to take that now. That would make sense. Okay. I'll let you start.
So we heard from the applicant's landscape and visual witness, Ms. Kelly Anderson, last week, of course, and she advised that in the evidence that she was presenting to the inquiry, she didn't address the policy test. She considered that to be a matter for the applicant's policy witness, Ms. Sidgwick. As I understand her evidence, Ms. Kelly Anderson reached conclusions on the impact of the national scenic area in respect of each special landscape quality, as that special landscape quality was expressed across the entirety of the NSA. That's what's set out in the EIAR. And it seems to me that what Ms. Sidgwick's done is read those conclusions directly across to reach conclusions on the policy test, to reach conclusions on policy 4C, Part 1 of NPF 4. However, as I was just explaining, I believe it is common ground between parties that the integrity of the national scenic area can potentially be compromised by a small number of special landscape qualities, or by a relatively small extent of a national scenic area being impacted. And it strikes me that a further analysis is accordingly required in order to translate the more high-level findings that Ms. Kelly Anderson's made into conclusions on the policy test. And I don't see that further analysis in Ms. Sidgwick's evidence on behalf of the applicant. And I wonder if she might have any comments on the approach that she's taking here to the application of the policy test at 4C Part 1.
Okay, Ms. Sidgwick, would you like to respond on that?
Yes, no, happy to respond on that. I think when the decision maker is looking at these policies, they have to consider all the evidence that is before them. They have to consider the position of the applicant, and they have to consider the position of the statutory consultees, including the local authority and things like that. They have to take that whole picture, if you like, and decide where they find in respect of it. I think what I've tried to do is set out how I think that process should be done, and I've indicated the conclusions that I might reach, but I understand and accept that other people may reach different conclusions in that matter. So what I'm trying to do is say, this is how I read the policy, this is how I think you have to interpret it, and these are the conclusions I reach, but others are entitled to come to different conclusions, and indeed they do.
Okay. So is there a specific point of your part of your report that you'd want to point to in terms of, you were saying you have said what the conclusions are that you would reach? on the policy balance that Mr. Gregg's talking about?
I think at the end of my conclusions, the second last paragraph, I talk about the acceptability of other or otherwise proposed development being a matter for the decision maker. I talk about the visual impacts on North Arran, the NSA, which are recognised by Ms. Kelly Anderson to be significant, but in my view, they don't outweigh the contribution that is made towards renewable energy generation and emissions reductions targets, etc. Along with the biodiversity enhancement of the proposed development. So in undertaking that final balance, which is the positives and the negatives, that's the conclusion I reach, because I then go on to say that it's respectfully submitted that the Section 36 consent should be granted.
Okay, and it's just a question to Mr. Gregg. So in essence, what you're saying, that there is a thought process between the analysis work that Ms. Anderson did and the conclusion there that you're expecting to see somewhere but aren't seeing?
That's right, ma'am. I think there is a gap, to my mind, there between the conclusions that Ms. Kelly Anderson reaches in an environmental impact assessment context and the application of the policy test. And by the policy test, I'm talking about policy 4C part 1, which is directed towards a consideration of whether objectives of designation or the overall integrity of the NSA is compromised. I don't think you can simply read across a conclusion on across the entirety of the NSA to reach findings on that part of the policy test. I think there needs to be a more fine-grained analysis to look at how those SLQs are expressed in particular parts of the national scenic area and how they are impacted in order to reach conclusions.
Okay, so Ms. Sedgwick, did you have anything you'd like to comment? Mr. Innes, do you want to comment on that?
Yeah, I'm just going to come back. I mean, Ms. Sedgwick, in her analysis in the third paragraph above, specifically identifies areas where there would be impacts. So it's not fair to say that it was just generically applied across the NSA. It was drawing from the findings within the assessment undertaken by Kelly Anderson, and then essentially setting out a conclusion. And that is the basis of the conclusion. So I don't think they are general; they are specific. You know, it is focused on where the special qualities are most affected, and that is reflected in our evidence. So I think that's an unfair analysis. This needs to be read as a whole, and I also consider that effectively the role of a planning witness isn't just to partake and put matters in a pejorative way, but also set the context for the policy and understanding of it. And certainly, I consider when you read Sedgwick's analysis in 712.1, it proceeds upon, in my submission, a really good understanding of the context before the conclusions and evidence are considered and reached, with a clear analysis of consideration of the decisions and also an understanding of the Nature Scots paper, which the draft paper which they produced. I suppose I could ask a question back. That's another draft paper we've seen from SNH. Is there ever any intention to complete the paper? Because clearly the analysis there is still portrayed as a draft. You know, in that discussion, I've asked the question. I suppose, you know, given that Mr. Gregg's asked the question, I'm just asking a question back, probably to Mr. Brooks. Is there any intention to finalise that document and to document, if I can ask that through the chair.
Yeah, and before I pass that question forward, can I just check that paragraph number from Mr. Drick's report that you mentioned then? I don't think I've written it down right.
We've got 7.1.2.1 on pages 32 to 33. And I would invite you to read the whole of the analysis because it builds to an understanding of context before a conclusion is expressed. So the conclusion isn't just a bold conclusion, it's based on an understanding of the various decisions and also the context note that S&H provided and a discussion of those. And so, as I say, I think it builds upon that understanding to drawing the conclusion from the evidence that was at that stage put forward at before the inquiry.
Okay, thank you. And I'll ask that question to you now, Mr. Brooks. It was a question regarding whether there is intention to take forward the draft guidance, complete it basically.
Yes, I can confirm that there is that intention. I cannot give you a timescale because I'm not aware. I'm stepped back from this bit of our work, and I can follow that up if that would be useful to you, ma'am, on that. This is a piece of work that we've been doing in discussion with both the National Park authorities so as to establish that agreed view, and I don't know whether there's a hold up with Nature Scott or whether there's been some delay with the National Park authorities, but I can clarify that if that would be helpful.
Yeah, I think that would be helpful. You could maybe include that in your closing statement when that comes. Okay. Thank you very much. So the next agenda item is item 5.
Was the last bullet.
Oh, sorry, I've skipped a bullet. And the last bullet on the section we're on is how should reference to the precautionary principle in criterion E be understood in this case? So just a reminder, we're on natural places at the moment. I will start with Nature Scott.
Thank you. I mean, our understanding of the precautionary principle is that it allows for decision making when there's scientific uncertainty, so that preventative or protective measures can still go ahead when there's harm, but you're doing it in a measured way. We don't consider that the precautionary principle is relevant to the NSA case because we're confident in the assessment of the landscape and visual impacts that's been undertaken on the NSA, and there aren't these uncertainties that tend to be more relevant when you're dealing with the ecological interests under policy 4.
Okay, and would the council like to add anything to that before I pass over to the applicant?
No, ma'am, thank you.
Okay, so the applicant's response to that, please.
Don't disagree with Nature Scott on that front. I think sort of thinking of it slightly wider than the landscape and visual effects, which Mr. Brooks referred to, the environmental impact assessment process has followed across the piece a fairly standard set of procedures and methodologies. There's been no criticism of those methodologies and procedures in terms of peat probing, hydrological monitoring, ecological monitoring, that kind of thing. We believe that the decision maker has all the information they require to take a competent decision without concerning themselves with the precautionary principle.
Okay. Thank you. Excuse my writing time. Okay, so I'll move on to agenda item 5 then on the components and status of the development plan. So we know that now that LDP2 has been adopted, that's been confirmed, and we've got the written statement before the inquiry. Does the adoption of LDP2 make a material change to the overall development plan policy position on wind farms? I'll start with the council on that.
Thank you, ma'am. LDP2 was adopted on 28th of February 2024. The written statement was modified following a direction from Scottish Ministers and is included as CD 007005. The LDP2 proposals maps are those which are included in the code documents list as CD 007010 and CD 007011. The renewable energy policy and the spatial framework for wind farms was one of the issues considered at the examination of LDP2. When NPF4 was adopted, the reporters issued a further information request in relation to both the policy and the spatial framework that was in the proposed LDP2. Following consideration of the responses, the reporters recommended that the spatial framework be removed from the plan and modifications be made to policy 30 to reflect what was in NPF4. The potential inconsistency that applied between LDP1, which was adopted in 2015, and NPF4, which was adopted in 2024, has therefore been removed. NPF4 and LDP2 are consistent with each other. So you could say there is a material change in that inconsistency between the previous plan has been removed with the adoption of LDP2. There's no longer a spatial framework in LDP2, and following the adoption of LDP2, LDP1 and the supplementary guidance 2 that was associated with it have fallen and are no longer part of the development plan.
Thank you, and I think you've probably answered the second part of agenda item 5 question as well, which was the statement of agreed matters notes that the adoption of NPF4 materially changed the policy framework for consideration of this proposal, suggesting compatibility between NPF4 and the spatial framework for wind farms that is in the supplementary guidance. And beyond that, are there relevant NPF4 policies broadly consistent with the LDP2? So I think from what you're saying is you're noting those changes, those inconsistencies aren't there, those specific inconsistencies aren't there now that LDP2's adopted. So
yes, well, I believe that's the case. The inconsistencies that would have existed before LDP2 was adopted have now been removed, so that both NPF4 and LDP2 are broadly consistent with each other.
Okay, and in terms of the part A question, I guess there's an opportunity there as well. Just are there any particularly important aspects of LDP2 to highlight that maybe aren't inconsistent with NPF4 but might not be present in NPF4? Is there some other specific policies in there that we should be considering that we wouldn't already be considering based on our analysis of that?
As I mentioned in earlier, the policy 30 in LDP2, which relates to renewable energy development, does still contain a criteria in relation to impacts on tourism and recreation. That's not inconsistent with NPF4, as I said before, in terms of I believe NPF4 still requires consideration to be given to those things which may be impacted in relation to tourism development. So I think that there is just some further detail in LDP2 to recognise the importance of tourism to the Argyll and Bute economy.
Okay, and I'll just quickly touch base with whether Nature Scott wants to say anything on either 5A or 5B before I pass over to the applicant.
No, we've nothing to add. Thank you.
Okay, so Ms. Sidgwick.
Yeah, thank you very much. I think just sort of reminding ourselves that because this is section 36, there isn't a primacy of the development plan, and I'm sure everybody knows that, but it's useful just to sort of bring that to the fore of the mind and things. I don't disagree with anything Mr. Lodge has said about the timescales and things like that. And in reading the introductory text to Policy 30 in the LDP2, I note that it says that Policy 30 should be read in the context of the development plan as a whole, including the objectives and principles of MPF4 and its topic-specific policies, including Policy 11. And I take that to mean that when one is reading and considering a proposed onshore wind farm, in the context of Policy 30, regard must be had to MPF4 and what that says. Whether or not it's an incompatibility in terms of the Town and Country Planning Act, but there are some challenges in Policy 30 when one compares it to the Policy 11 of MPF4. For example, it talks about there being no unacceptable environmental effects and things, and that isn't wording that we see following from MPF4 Policy 11 and things. But I think if one looks at the broader principle, the fact that one's to look at both documents together, I think you have to take it in the round. And I sort of thinking about the tourism and recreation, which is the obvious criteria which appears in the list in Policy 30 that doesn't appear in Policy 11. I think in taking that in the round with MPF4, one might consider things like the long distance routes and things which are considered and identified in Policy 11. I think the other thing I would note is that although the scale of contribution to renewable energy targets features in the list of criteria in Policy 30, the policy itself doesn't replicate the requirement of Policy 11 for significant weight and things. So there are differences, but I think you need to read the picture in the whole, and you can't discount MPF4 just because LDP2 is later on the date line.
Thank you. Is there anything final the council would like to say on this part of the agenda?
No, I think I've said everything I want to say, ma'am. Okay.
The next agenda topic is aviation safety. The question we've set out is, has there been any change in the council position on the compatibility of the proposed development with policies on this matter since the report of handling? That really recognises, I think, that in your report of handling you were noting the objections in their initial form, at least from NATS and Glasgow Prestwick Airport, deferring to them on technical matters, but you did specifically say that you would therefore see some issues in relation to LDP policy as it was at the time. I guess that was the LDP one. Is there anything that would have changed in that since that time for the council?
Thank you, ma'am. No, there's no change. Until confirmation is received from NATS and Glasgow Prestwick Airport that they have withdrawn their objections, then our position would remain the same. Thank you, ma'am.
Okay. Okay, and is there anything the applicant would want to say on that point?
Thank you.
No. Okay, so we'll move on to agenda item 7 on balancing the requirements. And parties have agreed that a proposal's benefits need to be weighed against its adverse effects. What weight ought to be given to NPF4 and the online wind? I've just got Alps written down. Onshore wind power statements, I'm sorry if I've got the name wrong, as material considerations relative to the requirements of the Electricity Act. I'll start with the applicant on that, please.
I think they are both very relevant documents, and I think significant weight should be attached to both of them, as in the case of NPF4, the position of the Scottish Government in respect of planning policy, and the OWPS in respect of that being Scottish Government policy. And I think it's really important that in this context, we don't just think about the wind turbines, we also think about the solar and battery elements. The OWPS talks about security of supply. That's document CD 005 19, and I think it talks about location of battery storage there and the value which that can add to schemes and things. So I think in considering both documents, they should both attract significant weight. They're both relevant considerations, and the OWPS in particular to consider co-location, which is proposed in this development.
Thank you. Would the council like to comment on this point?
Yes, ma'am, thank you. I think we would agree regarding the importance of these documents. Obviously, NPF4 contains the Scottish Minister's policy on renewable energy developments, Policy 11. Energy provides detailed criteria on which proposals can be considered against to assess their compliance with the requirements of Schedule 9, which seek to preserve the natural environment. And again, the onshore wind policy statement, while supportive of meeting net zero targets, requires it to be done in a manner which respects our natural environment relative to the requirements of the Electricity Act. Thank you, ma'am.
Thank you.
Are you getting Mr. O'Carroll's cold as well, Miss Knox? He's already passed it on to one reporter.
Oh, I hope not. I hope I'm immune.
Serious accusations flying about now. Okay. Does Nature Scott want to comment on this question relating to NPF4 and the OWPS?
Just to confirm, we agree what's being said. With these are of significant weight for the matters being considered here, and ultimately it's a decision for you and ministers as to what weight.
Thank you. So the second part of the question under agenda item 7 is the scale of power generation of a proposal a relevant consideration? I'll start with the council.
Thank you, ma'am. Yes, NPF4 policy 11 directs that in considering the identified impacts of an onshore wind proposal, significant weight will be placed on the contribution of the proposal to renewable energy generation targets and on greenhouse gas emissions reduction targets. And the onshore wind policy statement sets these targets. Thank you, ma'am.
Thank you very much. And the applicant?
Yes, I think it is they are a very relevant consideration. They're important consideration and things. And going back to the point I made in the last one, again, it's not just the generation capacity of the proposed turbines and the solar, but the ability of the battery to provide a degree of balancing mechanism to that is also important and mustn't be lost.
Thank you very much. Would Nature Scott like to add anything?
Thank you. Yes, we agree it is a relevant consideration. I'd also extend it to the consideration of policy 4C, the second limb of the test, given that talks about national benefits. I think we're now clarified that all agreed that whilst this development is a national development, that status in itself is not enough. And I think in applying policy 4C2, consideration of the benefits, and that includes its contribution to renewable targets, is a relevant consideration.
Thank you very much. Okay, so that brings us to the end of the set questions. Sound a bit like an examiner. Let's say that. I'll look for a show of hands now then on agenda item 8, whether there are any other relevant matters that parties would like to raise at this point. No. Mr. Innes.
Yes, I was just to say that Mr. Carroll shared his cold with me as well. I had it over the weekend, so.
My apologies, but if there's any consolation, I'm feeling much better, thank you.
I look forward to that phase. Okay, thanks very much. So I don't have much by way of closing remarks. I think. Oh, I'm sorry, Mr. Gregg.
It was just on the important topic of the cold to say that it's also shared with the Nature School team.
Very clear and cool.
Well, I think we need a bigger venue in future then, obviously.
It was quite complex.
My apologies to everyone affected.
Okay, so I don't have a lot by way of closing remarks. I was going to check which of you are going to be back when we reconvene on conditions. Will you be there, Mr. Innes? Yeah, and Mr. O'Carroll?
I will be there also, and Mr. Perkins will be with me as well.
Yes, I've got his name down. Nature's Scott, you're not part of that.
That's correct.
Are you? Okay, and we will have a representative from the Community Council coming now that they have submitted a note and conditional wording relating to noise. Just a quick note, it's an aside really for Mr. Innes. We sent out a note to participants for the aviation safety inquiry with an urgent question about potential alternative dates. And it was just to let you know that that had happened and that we really do very much need answers as soon as possible this week, because we are set to be going ahead on Monday, unless we can quickly get another date set.
Yeah, thank you, madam. I'm aware of that request being made, and I'm sure that it's being dealt with as quickly as possible. Thank you.
Thank you very much. So in terms of when those of us reconvene, I suggest we do have an hour for lunch. I think what I'll do, because there are some participants this afternoon that haven't been part of the call this morning, I'm going to suggest that we open the call for the conditions hearing at 2, but start in earnest at 2:15, just in case those people have any connection issues. So I will see you back ready to start at 2:15 on conditions, those who are coming, and thank you all very much for the discussion this morning.
Thank you.
Thank you.
Thank you, ma'am.
Bye. I'll get started. So this afternoon's hearing session on conditions forms part of the public inquiry into the application by Scottish Power Renewables UK Limited for consent under Section 36 of the Electricity Act 1989 and deemed planning permission to construct and operate the proposed Earraghail renewable energy development on land between Tarbert and Skipness on Kintyre Peninsula. The DPE reference for the case is WIN-130-8. My name is Tammy Swift-Adams and I am a reporter for the Scottish Government Division for Planning and Environmental Appeals, or DPEA. I and my colleague Karen Hayward, who's also on the call, Assistant Chief Reporter, have been appointed by the Scottish Ministers to prepare a report setting out our recommendations on whether or not the proposed development should be approved. Our colleague David Spears is also with us behind the scenes for technical support. I'd like to take introductions from the parties and some confirmation on who's participating for each party in this session. And before we get going in earnest, if each person who's being introduced can just say a quick hello of their own, if that's possible, then that will help us test the mics for each person, just check that I can hear you before we get started. So I will start with the applicant, please.
Good afternoon, madam. My name is Colin Innes. I'm a partner in the law firm of Sheffield Wedderburn and appear here on behalf of the applicants. I'm also accompanied by Alison Sidgwick, Director Onshore Consenting and Environment at Natural Power, who will comment on planning policy and guidance. I'm also accompanied by Rob Shepherd of Hayes Mackenzie, who are consultants in acoustics. And I'll ask Alison Sidgwick and Rob Shepherd just to introduce themselves now.
Good afternoon, everyone.
Hello.
Good afternoon, Rob Shepherd from Hayes Mackenzie, Associate Director here and an acoustic consultant. We carried out the noise assessment and the noise impact assessment presented for the EF.
Okay, thank you very much. Yes, I hear you both well there. If Mr. O'Carroll could do the same for the council, please.
Good afternoon, Maurice O'Carroll, advocate with the Scottish Bar. I'm representing the council today. I'm accompanied by Arlene Knox with Earraghail and Bute Council, who had a large part to play in the agreement of conditions or discussion of the conditions with the applicant. I'm also meant to be accompanied by Mr. Richard Perkins from Mott MacDonald, and I'm told he's still waiting in the waiting room. When he does finally appear, he can then introduce himself.
Okay. I can't see him in the waiting room, so he's maybe leaving and trying to rejoin, or he might like to do that. I can't see anybody there.
So he just sent me a WhatsApp message saying that he's still waiting. So be highly desirable if you were to be.
If he were to be here.
Yeah, I don't speak to David.
Okay, my colleague will just ask David to make sure he's got. There's a few links for different sessions, so maybe just make sure he's got the right one and he's in the right.
Yes.
The right waiting room for today.
Anyway, please don't let me stand in the way of your further instructions.
So we've also got a participant today representing Tarbert and Skipness Community Council, Mr. Grosvenor. Mr. Grosvenor, do you want to introduce yourself?
Yeah, my name is Melvin Grosvenor, Grosvenor Consultancy. I'm representing Tarbert and Skipness Community Council and also Skipness Estates.
Thank you very much for that. So hopefully this party will be with us shortly. We completed a policy hearing session this morning. We completed that in good time, and we're expecting, based on the relatively small number of conditions that are on the agenda, we're expecting to complete this session today. We've got tomorrow blocked out too if we do run over, but hopefully that won't be the case. We've got a few participants today who.
Can I just clarify that, Mr. O'Carroll, Mr. Spears is going to send you the link again, because we don't have your witness's email address to send the link to. So he's going to send you the link again to send on to him.
Okay, thank you.
Oh, I can do that.
Yeah,
Um,
thank you very much.
Oh,
I can do that. I'll do that now. Thank you.
okay.
Thank you.
Thank you, ma'am.
Thank you. So I was just going to run through a couple of housekeeping points that people who had just joined for this call won't have caught when I run through them at the beginning of the inquiry last week in Tarbert or this morning. Just a few key bullets. The first is, depending on how long we need, I will make sure that we take short breaks from time to time, sensible breaks in the discussions. If you could use your microphones when you're speaking, when you're not, that helps, and just clarity of sound for people. People who are on the call but just observing, if you keep your cameras off, but people who are on the call with an expectation to be actually participating, if you keep your cameras on, that means I can see who's here at any point, and if you're raising your hand, I'll be able to see you. So raise your real or your virtual hand if you need to attract my attention, and I'll keep up to date with that as well as I can. If you've got communication devices that you're using, that's fine, but please keep them on silent. Here's Mr. Perkin. And we don't have a fire alarm scheduled here today. Hey, welcome, Mr. Perkins. Thanks for being here. I've circulated an agenda in advance, so hopefully you've all got your copies of that and you've been able to see in advance which conditions it is we need to discuss. Are there any questions on procedure or on what I've said before we move on?
Mr. Perkins to introduce himself.
Yeah, you do, Mr. Perkins.
Good afternoon. Sorry about the glitch there getting into the meeting. I'm Richard Perkins. I'm a noise consultant at Mott MacDonald, and I've been representing Argyll and Bute Council in terms of their review and their position on noise and vibration in respect of this application.
Okay, thank you very much. So if there's no questions on what I've said, then we will begin. I've already made my introductory remarks, so I will move on to agenda item 2, which is discussion on those conditions proposed by the applicant but not yet agreed, or not agreed with Argyll and Bute Council. There's just one condition in this section, which is proposed condition 34 on operational noise. So could I invite the parties concerned to explain where they are in terms of the dispute and the reasons for it? And I'll just note before we start that this is the condition that the Community Council is also interested in. So could I ask Council to start by explaining their position on this condition?
Certainly. The issue of amplitude modulation is one that's done the rounds quite a lot over the last sort of 10 years or so. There's been a lot of work that's been done to firstly identify what it is, and there is a metric now that's recognised that aims to quantify what we mean by amplitude modulation. And just to be clear, every wind farm has elements of amplitude modulation. What we're talking about here is under certain conditions where that amplitude modulation can become accentuated and can lead to increased complaints and sleep disturbance from a wind farm. So the industry came up with a condition that was produced back in 2017 that's widely recognised and agreed by most parties as a suitable condition to control amplitude modulation. And the council believes in this particular case, where there are receptors within a kilometre of the wind farm and where we have noise limits that are derived relative to background, that an amplitude modulation condition is required. It requires a relatively small tweak to the noise condition, which is what we've proposed. Essentially, it seeks to control amplitude modulation, and in the event of a complaint that includes amplitude modulation, it also then requires the applicant's investigation to look into that element. Without that condition being present, if there were to be an issue in relation to amplitude modulation, the council would have no planning enforcement route available to them, and the burden of investigation would then fall upon the council to investigate through statutory nuisance. And my experience of looking at these things for other councils and other sites has been that statutory nuisance is not a satisfactory mechanism for controlling amplitude modulation, and therefore it's needed as a planning condition as part of the planning enforcement regime. I think you're on mute.
Thank you very much. Mr. Grosvenor, I was just going to ask you, is that explanation there broadly in line with the Community Council's concern and the reason why they are also asking for a amplitude modulation condition?
Yeah, broadly, I think there is a slight disagreement between us. Can I just, I don't know whether there's a core document reference number to this, but we submitted a note dated the 8th of March, which was basically a position statement for the Community Council, given the fact that we're permanent consultancy, particularly very late to the party here. We haven't had any opportunity to look at the noise impact assessment, and I've listed out the documents that we've referred to as to those submitted by the applicant. And we stated in that note that due to the fact that we weren't aware that there was a document submitted by the council, the Mott MacDonald document that Mr. Perkins refers to, we were just generally raising our concerns, and the position was that because we hadn't had a chance to look at the applicant's noise impact assessment, because we weren't aware of, at that time, of the council's position, our view was that, you know, we wouldn't have a lot of confidence in the applicant's noise conditions. Now, having read through the Mott MacDonald submission, we can see broadly in line there that the council have considered most of the issues. There are outstanding issues that I'd like to address either at this session or perhaps in written submissions, and where we are pleased to see a convergence is the fact that the council are looking for an amplitude modulation condition. We proposed an amplitude modulation condition without the knowledge that of the council's position on this, and we're suggesting the Denbrook condition. We've outlined a brief description of that condition in that note, which is condition 20. Now, our position would be, it would be for you, ma'am, to decide if there was to be an imposition of an amplitude modulation condition, which would be the preferred condition to be accepted, given that the position of the council and ourselves on behalf of the Community Council is that there should be an amplitude modulation condition. So as I said before, we converge on that. Now, there are other issues, but I think I'd like to hear from you as to where we go with those, if I can leave that with you at the moment.
Yeah, so the note that you refer to, it hasn't got a core document number yet because it's just come in this week, but it has been circulated earlier in the week to the people who are here today. So that was circulated to people on Monday, 11th of March, 11:13 a.m. So that is a note, and as you say, the accompanying Denbrook wording of a condition that Mr. James submitted submitted to us for the council. And I think what I would be interested to hear, and if the council has had a chance to look at that, I'd be interested to hear views on whether there are significant sort of functional differences between the wording that the council has been suggesting and the Denbrook condition, or whether there are those sort of both versions of the same thing. So could I go to the council on that, please?
You're on mute.
So I've done it myself there. I'm very familiar with the Denbrook condition that Mr. Grosvenor's put forward. My view on it would be, whilst it is a condition that's been set as an amplitude modulation condition, it was back in the early 2010s when that condition was set. And I think the industry has moved on, both in terms of the definition of what we mean by the type of amplitude modulation that people complain about. And that is what we refer to as the IOA metric. And we think that is the more appropriate definition of amplitude modulation. And the penalty scheme that the Denbrook condition set has again been has evolved over time, and what we're putting forward is what the majority of the industry now considers to be the definitive position on in respect of controlling amplitude modulation.
Okay, so there are two conditions that tackle the same issue, but one is a more recent one in the eyes of noise expert. Are you talking about the noise industry rather than the wind farm industry? Yeah, thank you for clarifying that. Okay, and Mr. Grosvenor, have you got any comments on that in terms of the difference between the two wordings?
Our position would be much the same as our fully qualified acoustician. We had this, I don't want to go into too much detail, but we had this discussion at the recent Clacky Glen inquiry, where our acoustician, Mr. Leshuson, was describing the benefits of the Denbrook condition over the IOA condition. I think, given that I haven't got, I can't refer to my acoustician, he's not on this call, and obviously he's not available today. Our position would be that an amplitude modulation condition, whether it's a Denbrook 1 or the IOA condition, would be a step forward rather than there being no condition.
Okay. Thank you very much. So could I bring the applicant in, please, to hear your position on a condition of this nature and the sort of two options that are there?
How we're going to deal with this is Alison Sidgwick is going to deal with the policy context first, and then Rob Shepherd's just going to give you an update on where we are in terms of development of further refinement of potential guidance, and may make reference to materials such as WSP report. I then want to come back and I'll deal with some of the specific wording with the conditions and approaches. Then I may ask Rob Shepherd for any additional points he wants to make on those. So we'll try and deal with it comprehensively in a single response rather than going backwards and forwards. So I'll first of all ask Ms. Sidgwick to deal with the policy, please.
Thank you. It's really very simple and quick from a policy point of view. I think if we look at the OWPS, which is document CD 0005.019, and that covers how noise is to be dealt with in the mind of the Scottish Government in their policy. And at paragraph 3.7.1, we see reference to the assessment and rating of noise from wind farms final report, DTI 1996, referred to as ETSU R97, which is its common name. And it talks about that providing the framework for the measurement of noise and for all applications are required to follow the framework and use it to assess and rate noise from wind and energy development. It then goes on and talks about the IOA, Good Practice Guide to the application of ETSU, and Mr. Shepherd's going to provide an update on that. And then at 3.7.4, it's clear that until such time as new guidance is produced, ETSU R97 should continue to be followed by applicants and used to assess and rate noise from wind energy developments. And that's the policy position in short. And I'll let Mr. Shepherd explain where the IOA review has got to.
Thank you, Mr. Shepherd.
Thank you. So from a policy point of view, I suppose in recent wind farm decisions, it's important to note that there's no consistency at the moment in the way amplitude modulation conditions are applied. And so in Scotland, you've had recent decisions which may or may not have amplitude modulation conditions. So there's no consistency there. And as you've just heard, there's no endorsement of Scottish Government of an amplitude modulation condition. Where I agree with Mr. Perkins in terms of where amplitude modulation could become a potential issue at receptor locations is where the level of modulation is above that which is envisaged within ETSU R97 under specific conditions where the receptor experiences those higher than expected levels of amplitude modulation, which is where there might become a necessity. Sorry. I can see you're speaking, but you're on mute. Everyone's on mute.
My fault. Mr. Adams is in control of the mute button, and I wasn't aware. I wasn't in it. Anyway, what I was basically saying was, can you slow down, please, because we have to take notes.
Of course.
So can you start all that again?
So, in summary, in terms of in terms of Scottish policy of applying amplitude modulation conditions, there is no consistent approach of applying an amplitude modulation condition on wind farm consents. There's been, in terms of the last year, in terms of consents, there's been wind farms with no amplitude modulation condition, some with a penalty condition, and some with a scheme-based condition. And as I said, the Scottish Government hasn't endorsed an amplitude modulation condition and said this is the condition that should be applied to wind farms. And that's the same across the UK. There's no government endorsed amplitude modulation condition to be applied to wind farms. And then in terms of the specifics, I was saying that I agree with Mr. Perkins in terms of the thresholds at which amplitude modulation becomes more significant. But it should be noted that the ETSU R97 noise limits, as Mr. Perkins rightly says, envisages that there's a degree of blade swish with operational wind farms. So there's an understanding that there is a degree of modulation expected with wind turbine noise that would be heard at receptor locations at residential properties. And it's under specific conditions where levels of modulation are above that expected level, where it might become a significant issue at receptor locations, depending on the context. And I'll come on to that a bit later, but in terms of the overall noise level experienced at the receptor location relative to existing background noise levels. So I think that sets out the overarching policy context and received noise in terms of modulation. In terms of this site, and this is where I don't think that an amplitude modulation is necessary, so it fails the test of a planning condition in that respect, because it's only necessary where there's a significant chance of an amplitude modulation issue occurring in practice that requires control. And so in this case, it comes back to how far the receptors are away from the proposed development. And Mr. Perkins was saying that they wouldn't normally expect an amplitude modulation condition where the distances are greater than 1 kilometre from receptors to the wind farm. And I think in this case, distances to the nearest turbines is greater than 1 kilometre. With reference to the predicted operational noise levels presented within the EIA, predictions were carried out for 3 candidate turbines, and the results of those are presented with on line charts with the reference CD 001.117. They're the noise assessment charts that informed the acceptability of the noise impact relative to the derived ETSU R97 noise limits. Those assessment charts show that for all 3 of the candidate turbines that were assessed in the environmental impact assessment, the noise limits are met by a minimum margin of 5 dB. And so there's a large headroom between the lowest limits applied, which are during the daytime, and the predicted operational noise levels for the 3 candidate turbines that were assessed. So the maximum predicted noise level at any property under downwind propagation conditions at the wind speeds at which the turbines have reached their maximum sound power level, so that's specific wind speed and wind direction conditions, is 30.9 dB LA90 at Knocknescratha. That's 4 dB below the ETSU R97 simplified noise limit of 35 dB LA90 that applies irrespective of background noise levels. And as I say, that's 5 dB, a minimum of 5 dB below the noise limits that are applied within the EIA and indeed within the noise limit values that are agreed between the council and the applicant in terms of the noise limits that apply at each property during the daytime and the nighttime within the planning condition. So it's important to remember that in terms of the context of the noise condition, the applicant and the council are agreed in all respects except for the amplitude modulation. So the noise limits that are applied are agreed, and they are set at the lowest daytime limits within ETSU once background is taken into account. That the daytime noise limits are set at 35 or 5 dB above background, whichever is the greater. And there's an allowable range within ETSU R97 for the daytime lower limiting value. So a choice of lower limit between the 35 and 40 dB range can be applied in certain circumstances. So there are conditions where you would allow 40 dB or 5 dB above background during the daytime. But in this case, the limit applied is at the lowest end of the daytime noise limit, so 30 dB or 5 above background. Similarly, at nighttime, the agreed noise limits have been set at 38 dB or 5 dB above background, whichever is the greater. And again, the applicant has agreed with the council to apply a lower limit than the ETSU R97 limit of 43 dB or 5 dB above background at night. And that was on the basis that the development didn't need to take up the whole limit. And the council asked, can we reduce it by 5 dB to 38 or 5 dB above background? And that was accepted by the applicant as being reasonable, and therefore they're the limits that have applied within the agreed conditions. So where we are now is that the predicted noise levels, as I say, are a minimum of 5 dB below the daytime noise limit and a minimum of 8 dB below the lower agreed nighttime noise limits. So even further below the ETSU R97 noise limits. And so that, in terms of the relevance of AM and the necessity of a condition, brings me on to, is there a likelihood or a chance that amplitude modulation at this site could be a significant factor in complaints? And in addition to looking at the relative margin between the predicted noise levels and the noise limits, we can look at the existing background noise levels that were measured at the 2 baseline noise measurement locations, of which are shown at table 13.8 of the EIA, which is the noise chapter core document references 001.014.
Okay, just let me open that a second.
Of course.
Table 13.8.
That's it.
Okay, I've got that.
And so what that shows is that broadly the predicted noise levels are within the range of background noise levels. At lower wind speeds and at high wind speeds, operational noise levels are below background. And where amplitude modulation might be a significant factor in a complaint is where the specific circumstances under which higher levels of expected amplitude modulation occur, and where turbine noise is dominant above the background. And so this comes back to my original point about necessity, where I believe in this case an AM condition isn't necessary in the context of the likelihood of excess amplitude modulation causing any significant complaints. Overarching, I think most wind farms operate without significant amplitude modulation, but there's not a methodology whereby you can predict whether or not it's going to occur at a specific site, although there are conditions relating to blade pitch angles and site-specific conditions that appear to be likely to result in higher levels of modulation, in which case, if those conditions occur, mechanisms can be put in place in terms of changing pitch angles or changing the operational condition of the turbine to reduce the levels of amplitude modulation. And so where an amplitude modulation might be considered to be necessary is where we've got predicted noise levels at the upper end of the bounds of the ETSU R97 noise limits. So, for example, if we had a site where the predicted noise levels were 40 dB LA90 during the daytime, and the noise limit was set at 40 dB LA90, and background noise levels were, for argument's sake, 30 dB LA90, you have the chance of operational wind turbine noise, usually under worst case downwind propagation conditions, significantly above the background noise level and up at the upper bound of the allowable limits within the ETSU R97 range. In that case, notwithstanding the unknown as to whether excess amplitude modulation may or may not occur, and as I say, most sites operate without excessive AM, but if it were to occur and you've already got noise from the wind farm that is significantly above background noise levels and at the noise limit, then any additional character that's received at the receptor location that makes that noise more noticeable could be potentially significant, and that might be a case where an amplitude modulation condition could be considered. But as I say, in this case, the relevant noise limits are met by at least 5 dB, and those are the lower limits that we're working to, not the upper range within ETSU during the day or the night. And under worst case propagation conditions as assessed within the EIA, we are generally around or below background noise levels as they are at the moment. And bearing in mind that that operational noise levels vary with wind speed and wind direction, when the receptor locations aren't in the downwind condition from the wind farm, then the operational noise levels will be lower than those that are set out within the EIA.
Thank you.
So if you'd like me to continue in terms of the proposed amplitude modulation conditions and sort of where we are with them and where things are going, then I can do that. It might be helpful to cover that off now, unless you want to talk about the kind of overarching need for an AM condition.
I just wanted to ask one just clarificatory question from what you've said. So it sounds like from the explanation that you've given and the information that you've pointed us towards just there, that what you're saying overall is because of the reasons you set out, you don't think an amplitude modulation condition is necessary. So that's the main, that's the sort of the underlining point of all of that you've said, I think.
That's correct.
Okay. So yeah, I'm happy for you to continue.
Okay, thank you. So in terms of we have 3 proposed amplitude modulation conditions here. So the council have proposed 2 conditions. One of them is a penalty-based condition. One is a scheme-based condition, which is designed to try and get around the limitations of the penalty-based system, which I'll come back to. And then the third condition is the Denbrook condition that's been put forward by Mr. Grosvenor. To deal with them in that order, the penalty-based condition is based on a penalty scheme that was devised in the DEC amplitude modulation review 2016, where the Institute of Acoustics amplitude modulation metric is used to determine the level of amplitude modulation. And this is where I agree with Mr. Perkins that the IOA amplitude modulation metric is current best practice in how to quantify the levels of amplitude modulation occurring from a wind farm. And so that metric was taken, and then a penalty system devised using those metrics to say for what levels of modulation, according to the IOA AM metric, what's the human response to that, and therefore what would be an appropriate penalty to add on to the received noise to counter that character, to sort of balance what would the sound be like without that character, what would be the equivalent overall sound level. It's much in the same way that there's a tonal penalty, and because a tone is a character that attracts your attention, it's potentially perceived as more annoying, and there's a tonal penalty rating system within the planning conditions that adds on an extra penalty to your received noise if that character occurs. And so my problem with the noise limit, the noise penalty system, is that it was born out of the DEC review from 2016. As Mr. Perkins correctly says, there was a agreed paper published in the Acoustics Bulletin in 2017, which set out a proposed amplitude modulation condition, which is what the council's condition is based upon. But it's the penalty rating within that system that has evolved since that original position back in 2016. And so the knowledge has moved on in terms of human perception of the level of modulation. And I'm not sure that it's quite appropriate to set a fixed rating penalty to a level of modulation determined using the IOA metric, because there are other factors that come into play in terms of determining the human response to those levels of modulation. And so, for example, the modulation frequency has a bearing on the response to the level of modulation that's occurring. So you might have an IOA amplitude modulation rating level of 4 dB, but whether that 4 dB rating level refers to a slower or a faster blade passing frequency. So that's what, when we talk about the modulation frequency, it's the frequency at which the sound goes up and down. And so for a faster spinning turbine, it's quicker, and for a slower spinning turbine, it's slower. But the modulation frequency itself has a bearing on how that sound is perceived, and therefore would have a bearing on the level of penalty applied to any received sound. And so that's an additional nuance within the sound that's received that's not covered with the penalty. And so there have been developments within trying to refine that penalty scheme to have different levels of penalty associated with a modulation frequency that varies, so that you can take into account that human response to the sound. And the other factor that is a significant factor in terms of the human response to the level of modulation is that level of modulation relative to the background noise level. And again, that's not something that's picked up within the penalty scheme. It's a flat penalty depending on the IOA rating level, but it's not related to the overall level of sound. And so where the overall level is lower, the impact from a modulating sound might be lower than it is if it's presented at a higher sound level. In terms of the DEC penalty itself, it's worth noting that within its proposal of the penalty system, it says that any condition developed using the elements proposed in this study, which includes the penalty system, should be subject to a period of testing and review. The period should cover a number of sites where the condition has been implemented and would typically be in the order of 2 to 5 years from planning approval being granted. And so we're not at a stage now where this penalty system has been rigorously tested in practice to determine whether A, the human response is appropriately represented by the penalty that's added on to the received sound, and then B, whether the metrics in terms of adding the penalty where AM is an issue then allows it to be suitably controlled and therefore become not an issue. The other side note in terms of the penalty system, I think is acknowledged within the rating levels, that human perception sound listening test to determine the equivalent difference between the penalty value with and without modulation tended to indicate a maximum equivalent difference of 3.5 dB. But the decision within the DEC study was to apply a 5 dB penalty, acknowledging that that didn't necessarily accord with human response to the sound, but was done on a conservative basis to cover a wider range of modulation frequencies. So I think in terms of that specific condition that relies on the IOA amplitude modulation metric and then assigning a penalty, like I say, where I agree with Mr. Perkins, the IOA amplitude modulation metric is a very good method for determining the levels of AM and being able to correlate them with specific conditions. But I think we've moved on since then in terms of the penalty, and don't necessarily have the assurances that those penalty values are necessarily appropriate. And I, again, I agree with Mr. Perkins that at the time in 2017, that was the best available penalty scheme to apply relative to an IOA AM metric. But since then, I'm not sure that those are necessarily the appropriate values to apply.
Okay, so where are you going to come on to tell us in terms of things having moved on, where they've moved on to in terms of what the appropriate alternative under current thinking would be, or is that not interrupting your flow?
No, that's fine. I can talk about that now, and then go on to the other two proposed AM conditions. What we have now, as I say, is a well-defined metric for quantifying the levels of modulation. What we don't have is the kind of the human response to that, how it should be applied in terms of a planning condition. So I don't have the answer here as to say this is what an alternative amplitude modulation condition would be to apply at this site. But in terms of going back to this site specifics, I don't think there's the necessity, because the likelihood of significant excess amplitude modulation occurring at this site is very low. I think if there were any wind farm sites where an amplitude modulation wasn't required, then it's this. You know, there's very few wind farms where noise is discussed at an inquiry or hearing stage where predicted noise levels are so low. And so we've got a large margin to the lowest limits within ETSU. So I think it is worth coming back to the specifics of this site to think about the necessity. But I don't have the answer in terms of, if we did need to apply an amplitude modulation condition, what would be the alternative? Because there's ongoing research as to what that appropriate mechanism would be. What I can say in terms of other sites where there isn't an amplitude modulation condition, and there is amplitude modulation that's excessive, controls can be put in place to reduce those levels of modulation using pitch control mechanisms or other mechanisms. And it is a character of sound that is encompassed within a nuisance. And so if it was something that falls under nuisance legislation, then the IOA AM metric, as I say, it gives a rigorous and repeatable method of saying what levels of AM occur and under what conditions do they occur. And then we can say, under these specific conditions, levels are above 3 dB, for example, as being the level at which excess AM could be defined. And then under those specific conditions, you can say, well, is that a significant effect? And what can we do to reduce it in that respect? So if it's not conditioned, albeit that it might not be ideal to leave it to nuisance, it does fall very neatly within nuisance as one of those factors that would be assessed in terms of determining what the significance of the impact is at receptor locations, which would then take into account the overall noise levels and any other characters.
Okay, I'll let you move on to your comments on the second council condition approach.
So the second council approach was a scheme-based condition, and that was designed to try and overcome the limitations I've talked about in terms of the penalty-based condition. Because work in the area is evolving, and that human response to the levels of AM isn't rigorously defined and might change over time as there's more research, the scheme-based condition allows some flexibility in a change to the metric if the IOA AM metric is updated to improve it in some way. And for example, there might be an international standard that comes in that deals with measurements at receptor locations that includes amplitude modulation and a metric within it. In which case, if there's an international standard, you might refer to that rather than the IOA AM metric. And then the response to the levels of AM will be better understood as there's more data collected. And then so it allows the flexibility in applying an appropriate or updated limit or penalty for any given levels of amplitude modulation. So that's where the scheme came in and was brought in as a something to try and overcome the hurdles of a penalty-based limit. I know in terms of the scheme versus the limit condition, I know the council have mentioned that Sankar 2 had a amplitude modulation condition attached to it, but the AM limits within the Sankar 2 decision was a scheme-based approach rather than a penalty-based approach. So it used this second approach rather than being a penalty-based approach. And I think Mr. Innes will come on to the kind of the technical, or not the planning condition tests of both those conditions, because I understand there might be some limitations in terms of a scheme-based condition meeting the necessary tests.
Can I ask you a question there? But you mentioned there had been an AM condition, scheme-based AM condition at Sanka. Were the noise assessment findings similar or different between Sanka and Earraghail? So was that condition applied in similar noise circumstances for residential receptors as we see here, or was it quite different?
It's a very different situation at Sanka too. You've got receptors that are receiving noise up at the upper end of the ETSU noise limits, and it's an area where there's a significant amount of wind farm development, and so receptors are subject to noise from more than one wind farm potentially. It's certainly not a wind farm where predicted operational noise levels were 5 dB below the ETSU lower daytime limit. In terms of the Denbrook condition, I don't have an awful lot to say about this, apart from I strongly urge you not to consider it as an appropriate control for amplitude modulation. It's a condition that's been applied to one wind farm in England, in Devon, and it was applied in 2009. Since then, that condition hasn't been applied to any other wind farms in the UK. It certainly hasn't been applied to any wind farms in Scotland. The way it's presented cannot just be readily applied without a detailed set of notes that go alongside it on how you would apply that in practice. You know, as Mr. Perkins was saying, it's a condition that hasn't actually been tested in anger, and it's something that there's been tests to try and put through data through the Denbrook amplitude modulation conditions, and you can measure in an area where there aren't wind farms and you get a lot of false positives, and that condition exceeded. It's not a rigorous test of amplitude modulation from wind farms, and so it's not appropriate to use as a necessary condition. Since 2009, we've got the IOAAM metric, came out in 2016, and as I say, that offers a robust method and repeatable method of determining the levels of modulation, and so that's where we are now. If an amplitude modulation is required, then it should be based on a well-defined and agreed metric, rather than the Denbrook condition, which was put forward by a single consultancy at the time and wasn't necessarily backed up with any specific evidence as to how they'd chosen those values within each of the elements that's proposed to determine the significance and the number of peak to trough values within the relevant assessment periods.
Is the Denbrook condition a penalty or a scheme-based condition or something else?
It's something else. I know Mr. Perkins referred to it as a penalty-based condition, but it doesn't actually have a penalty associated with it. It's not a scheme-based condition because it defines it within itself what the allowable conditions are, but it just sets a level that shouldn't be exceeded. It doesn't say what to do if that level is exceeded. It just says these are the conditions. That tells you whether or not the condition is met or not.
Okay. Okay, thank you. Is that the end of your part of the?
I think that's the end of me.
Okay. Okay, Mr. Innes.
So I hope to be brief. What Mr. Shepherd has set out in some detail is providing this context about the development or understanding regarding AM. and its potential control. Insofar as any change to ETSU is concerned, is that WSP were commissioned by the Department of Business, Energy and Industrial Strategy, BEIS, which is now obviously, I never find it quite hard to keep up with the UK government changes, but I don't think it's called that anymore. But they commissioned WSP to do a report, and that was delivered to them at the end of May 2023. As I understand it, UK government is still considering that report, and the report wasn't just a single set of recommendations. It was also about further work that might be required potentially to take matters further forward in considering a replacement of ETSU. So as it currently stands, the UK government is, as I understand it, waiting to respond to the WSP report. And certainly, I think there are soundings that might be being developed over the next period of time, that there is likely to be movement on that. Insofar as the council conditions are concerned, I want to deal first of all with the effectively the penalty-based one, and turn to page 10 of the CD 14014006.
Page which? Sorry, about the document page.
It's 14.006, which is the council's hearing statement with the, and it's got we're still on guiding those 5 as the AM penalty. And on page 10, we're in the top of that page 10 is the guide state 5. And in the penultimate paragraph, it's dealing with effectively the application of penalty. And we see about halfway down that second last paragraph, the assessment level in each bin is normally the arithmetic sum of the L90, the bin tone or same characteristic, amplitude modulated tones, when the sum of both penalties may overly penalise the characteristics of noise. And in essence, what this is dealing with is the overlap between potentially applying an AM penalty and a tonal penalty. And effectively, a judgment is having to be made essentially about the overlap. And in those circumstances, when individual judgment is made, the larger of the AM or tonal penalty should be applied. Now, one of the issues about these types of condition is that compliance is a criminal offence. You need to know where you stand. And in effect, that's a judgment call that's having to be made as to how that's applied. And that's one of the problems in the penalty position as well, is the potential overlap between applying a tonal penalty and applying an AM penalty and the judgment that's required in that. And that becomes problematic in terms of the precision of a condition and ultimately its enforceability. And I think one of the problems that we have to remember is that ultimately these conditions, if not complied with, can be a criminal offence. It therefore sets a very high standard in terms of setting out what's required and being clear and precise. And that's why we have policy considerations that come into the formulation of conditions, and they require them to be both enforceable and precise, because these are precisely the issues that come to bear if there is a lack of precision or enforceability. And I say that is problematic as it's currently drafted. I then come to the next page 11, which is the scheme approach, and that certainly fails the precision test. It certainly fails the enforceability test, and is in effect deferment of setting a policy requirement. That is not competent and would be problematic should enforcement be attempted. And in those circumstances, it doesn't meet the legal requirements of either a condition nor the policy requirements of general policy. And furthermore, in terms of the last test, Denbrook condition, we've heard the limitations, but in order to impose a condition, it must be justifiable and reasonable in all other respects. And unless you put forward in this context a very clear articulation of why those particular levels are of a particular are justified, then it can't be reasonable to impose that condition. So on the basis of Mr. Shepherd's evidence, it wouldn't be lawful to impose that condition at this stage either. But what I would say in overall position is, as it currently stands, there is still further work which requires to be done to take the IOA position of a degree of consensus and turning it into adequate conditions that can be applied lawfully in a consent. And in terms of that process, it is clear that the UK government is currently undertaking that review, and no doubt in terms of establishing a response in terms of ETSU, will engage with a wide range of parties to ensure that whatever comes out of that process is one which stands the test of that type of scrutiny and can be imposed without the problems that we've identified. And it also demonstrates why there is a need for the government to seek further advice from a range of specialists to enable them to take the matter forward. And that, as I understand it, is what is intended. And the difficulty in the absence is that there are limitations with each of the approaches that are set out. And the limitations are quite extreme in the sense of their ability to comply, both with the legal requirements of imposing a condition and also the policy requirements. As I say, until that exercise is complete, there are serious issues with the drafting of the conditions that have been put forward for this inquiry. And that, in a nutshell, reflects a fairly lengthy response on the applicant to this whole issue. But having ventilated, obviously, it's rather as a comment. But that's the applicant's position.
Okay. I'll come to you in a minute, Mr. Grosvenor, because there was a question I was going to ask you anyway. It's just a follow-up question for Mr. Innes. So you and Mr. Shepherd have set out the problems with the wording of the three conditions that are before you, basically outlining that in your view they would all be problematic in various ways. You've talked about the UK government work going on to look at what might be an unproblematic way of dealing with this through a condition. So are you saying that at the moment it is not possible to create an unproblematic condition to deal with amplitude modulation if it was a circumstance where that was thought to be a problem? Is it possible now to do an all right condition?
Well, whenever we've dealt with these matters before, we've always been very upfront with the challenges that the current set of conditions essentially give rise to. And I still haven't seen a response that adequately deals with these issues. That does seem to suggest that it's not straightforward and that it will require, I mean, we have thought about it. We've sort of tried to see how we can make it work. At the moment, it doesn't appear to be straightforward. And the other aspect is, I think, as is identified by WSP, there is further work that has been undertaken, and the whole issue, it needs to be brought together. And whilst there may be agreement on certain aspects, as Mr. Shepherd's identified, there are other aspects over and above those which were identified in the metric that further require consideration. And the right place for these to be considered is by government and expert groups. And the difficulty is, I suspect that is why the government set out in the onshore wind policy statement a clear explicit statement about we're applying ETSU till it's replaced, because effectively it's not the right place to try and deal with these matters in application settings. There needs to be a consensus. There needs to be a clearly articulated group that come together that try and resolve the issues that we've identified, and to see whether an effective condition can be brought. I also don't agree with the position that nuisance can't be an effective remedy. Parliament's passed it. The 1990 Act has been in force now for a considerable period of time and provides a very effective remedy where nuisance exists. And the Scottish courts have used the Environmental Protection Act to deal with AM issues. And in those circumstances, rather than taking a measurement view to it, they've just taken a slightly different view, which is expert evidence on the nature and character of the sound to find whether a nuisance exists rather than empirically measuring it. And that is an alternative position. And it's one that government may say, actually, we've done the study, AM is an issue at a percentage of sites. Given that position, we feel that actually, rather than doing planning conditions, that actually nuisance might be the right way. And actually what we've now got is much better information for everyone about human response and what is likely to give rise to nuisance. So it's not a definitive outcome that will inevitably be a condition. A perfectly acceptable outcome may be for government to say, actually, we've looked at the competing arguments, we've got the data, we've got the better research. We still feel actually a condition is not the right way to go. That would be prejudging the issue, because that may well be one outcome. And as I say, it has been used. It's not a remedy that is not used. Statutory nuisance exists in many respects, might be viewed if, as we say, the AM is a relatively rare outturn and it's not predictable. Nuisance may often be the outturner for that type of circumstance. And also the control mechanism of the enforcement notice is bolstered by the potential threat again of criminal sanction. But obviously there's a right to appeal, and if it's upheld by the sheriff, then it becomes a matter of legal requirement to comply with it.
Okay. And so we've talked about some of the perceived issues in terms of the different ways of wording conditions like this and the tests for conditions. Is there any evidence that's gone beyond that in terms of these, where there is thought to be a risk of amplitude modulation and condition has been used and it has tried to be used in practice? Has that happened and caused problems? Or at the moment, is it that there are conditions sitting there on some consents that could be problematic if they come to be used? Mr. Innes.
So does the Shepherd want to answer in the first instance?
I'm not sure it's been tested in practice, to my knowledge, on sites which have an amplitude modulation condition where compliance measurements, including amplitude modulation, have been carried out to determine the level of amplitude modulation, and then whether a penalty was applied, and then whether or not that results in compliance with the limits or otherwise, and then whether a remedy is acceptable. So, to my knowledge, yes, I don't know the answer to that question. We've certainly applied the IOAM metric to data and on other sites to determine levels of AM under specific conditions, and looked at what would happen if you added the penalty on. But in terms of any sites with a planning condition where I've carried out compliance measurements and incorporated that penalty, I haven't been involved in any.
Okay, thank you. Did you want to Mr. List, anything to that?
I'm not aware of conditions being applied. I'm aware of nuisance cases being brought because they're published. If somebody appeals to the sheriff, and then there's a full determination of published judgment. And there have been a number of occasions in Scotland where that has been progressed, where nuisance has been used as a remedy.
Thank you. Mr. Graver, I said I'd come back to you, and I will. It was just a question that occurred to me when Mr. Shepherd was speaking, which was Do you know why it's the Denbrook condition that's all come to the surface? Is that just an example that somebody's found, or is it one that somebody's compared to other approaches and prefers in terms of who's advising the community council?
Well, the Denbrook condition was a tested condition. Our acoustician described how it could be applied, as said before, at the Clacky Glen inquiry. I take all the points that Mr. Innes makes in terms of the WSP review. We do have information that it looks like the DESNES, which is the new department, is looking to publish results of the WSP report in 2025. So it's some way off. And the issue that we have, which remains, is that despite Mr. Innes saying that there have been statutory nuisance cases going through the courts, I'm not particularly aware of them. Mr. Perkins' position is that the local authorities are finding it difficult to pursue those, mainly because of the cost involved. So there is an issue here, and of course our position is that primarily, first and foremost, is that yes, that Mr. Innes implies that the condition is serious because there could be criminal proceedings, but at the end of the day, the priority should be for this inquiry or for this hearing is that to ensure that the residential amenity of the residents is protected as first priority. And what we're trying to do in this condition session, and I believe perhaps Mr. Perkins would agree with me, is to look at every ways where that can take place. Now, because the WSP review is a little way off, we do know that even if this scheme is going to be consented, it will be some time before it's built. And I'm putting this out as just a hook, if you like. There wouldn't be any possibility of saying, well, we'll hold the condition and set the condition once it's been consented and ready for operation. I just put that out as a thought more than anything else, and perhaps Mr. Innes would like to come back on that point.
Would you, Mr. Innes?
I'm afraid you only get one go at producing the conditions, and that's the nature of this process, unfortunately. And that's just the nature. We get one go at producing a set of conditions, and you can't defer and just say I'm going to defer having the conditions set in 2025 or 2026 on the basis of what might happen then. We just have to go on the current evidence, the evidence that's based on where we are in terms of policy and guidance and the rules that apply. And that's where we are. And as I think we've set out our position, and it is a developing field, and we acknowledge that, and we're fully aware of and understand the developments in the field. At the current time, we haven't built the right framework.
Yeah, and the point about that, and that's the answer I expected you to provide, Mr. Innes. Unfortunately, the buck stops with the residents, who may well be in a position where they have to complain. Unfortunately, so that's where. So it's a difficult one, but we would hold the position that the council is taking, and request that, if possible, an AM condition, even if it is the IOA condition, is applied in this instance.
Thank you. And I'm going to pass back to the council, if that's okay, to see whether you have any observations on all of that you have heard, not on all of it, on any of it that you have heard. In particular, this discussion point around the option of using other controls. You did say at the outset that you didn't think they were preferable. I just wonder if you might want to say anything more on that, having heard from the applicant?
Certainly, there was a lot of ground covered there. I think the difficulty here, as has been pointed out, is that we all want to be in a position where we're providing an appropriate level of remedy in the event that these issues may occur, and amplitude modulation is something that could occur. I don't think anyone here could say definitely won't occur. In the event that it does occur, the residents would like to feel that something, if it was excessive and leading to sleep disturbance, particularly at night, is where I would say the biggest concern would be. They would they would know that the council has some way of helping to investigate and to bring about a remedy. I mean, to be fair to the operator, they don't want a turbine to be running with lots of excess amplitude modulation, because it's not the best operating condition for the turbine. So it is in their interest to deal with it anyway. But at the same time, what we wouldn't want is long periods of time where the excess amplitude modulation is causing loss of amenity to the local residents. And I accept that Mr. Shepherd has gone through some of the limitations of the IOA scheme, and it was derived, it's 6.5 years old now, but it is the one that's there. It has elements that arguably the understanding has slightly moved on, but only in terms of the acceptability. As Mr. Shepherd admitted, the metric has not changed since the IOA metric has been developed. So we all agreed that's how we generate the number that is called excessive amplitude modulation, and that's how we would go out and measure it. So in that regard, it's very precise and meets all of the tests that we would require for a planning condition. Where there is slight ambiguity is over what a penalty scheme might be. And Mr. Shepherd's actually made out a good case to say in this particular instance, because we're quite close to background in some wind speeds, actually the penalty may not do an awful lot. And actually that points the finger and say, well, actually, did we get the numbers right in the penalty scheme? That and arguably, should we have make that penalty 3 dB higher so that actually the AM condition would actually kick in and work as intended? That if the AM was actually causing problems, there is a remedy and something would happen to try and reduce that position. So I think that would be where we're coming from as the council. We would like to see a control. We accept that there is, certainly the scheme-based one, it is, how it met the 6 tests or was deemed to meet the 6 tests for the Sanquhar 2, I don't know, to pick up Mr. Innes's point, but clearly it did. So it's there, and we would certainly point to that as being obviously it's a more flexible scheme in that the applicant would have to propose what they're going to do in response to any excess AM that they found, with a penalty scheme to be agreed at a later date. And I can understand why there might be reservations over that approach. But I think to not put the condition in, yes, there is statutory nuisance provisions, but my experience of that statutory nuisance is that it doesn't, against the larger wind farm schemes, it does not bring about the results that are likely desired for protection of amenity. The bar for statutory nuisance is different to the one for planning. Yes, the tests are different as well, as Mr. Shepherd had rightly pointed out in the WSP report of 2016, which, I just point out, I was actually the author of that report, so I do know it quite well. And the attempt in that report was to produce a condition or lead towards the development of a condition that would meet the 6 tests and would be acceptable. And what I heard earlier was actually we don't like it because actually human response may be slightly different to the way the penalty scheme was derived. I don't think that's enough of a reason to not accept that condition as being an acceptable one for you to consider.
Okay, thank you very much. And I've just got one final question for you, which is similar to one I asked the applicant, which is, have you got examples of where you've had an AM condition in place and you've needed to use it, or where you haven't had one and that's caused a problem?
I haven't got any examples of the first. I am aware of several examples of the second. In fact, quite a few examples of where the planning condition didn't contain an amplitude modulation condition, and as a result, loss of amenity has occurred without the resident having any significant redress through the statutory regime. They still had private nuisance as a potential option, but experience of all the cases I'm aware of is that under private nuisance, they never see the light of day in court and they all get settled out of court. So there's never a precedent set in the courts that I'm aware of.
Okay. And I'll, obviously that's, I've asked you the question that wasn't on the agenda, so it's anecdotal, slightly in nature, but thank you.
Indeed.
I'm going to finish this agenda item unless anybody's got any more they want to say on it. No. Okay, shall we take? Oh, I'm sorry.
I've got a couple more comments.
Okay.
I think the thing is, as I said at the beginning, we've been quite new to any form of review of it, i.e. the council's submission and also the applicant. Now, I don't intend to review the applicant's submission in any great detail. What I would like to say on behalf of the community at this point in time, because the question hasn't been asked and I think it should be asked, our position is that in terms of the limits, they are low limits, 35 dB and 38 dB, nighttime limits, DPA, and that is welcome. I am concerned that the council suggests that it's good to have the lower limits because this would allow sufficient headroom for the applicant and other to have a planning advantage to provide any further scope for development in the area. I'm quite concerned on behalf of the community about that. Any planning condition or planning limits should be set purely to protect residential amenity and not to provide an opportunity, however desirable, for further applications to come forward. So that's a point I would like to raise at this point. And we are concerned that as identified by the council, there hasn't been any noise contour plots. Although the council say that it's an issue that is not material or not significant, we would disagree with that. And the reason why I say that is that we are concerned about one of the derelict properties that is being put forward for development. That's the Alavash property.
Alvash, I think.
Alvash. Sorry about that. And of course, what we have there, without a noise contour plot, we don't know what if that property came forward. And I think it's a matter of perhaps dispute between the applicant of that, or the developer, or the person who owns that property, and the council. We're concerned that it's been excluded. We don't know what the limits on that would be. It's much closer to the closest turbines. I understand it's 800 meters, and that is an issue that we feel that should not just be disregarded. Now,
okay, I'm gonna interject just because this has been dealt with through separate procedures. So
right.
Had an exchange in writing on this. It came up in the community hearing.
Yeah.
And particularly because we've only just had the detailed noise comments from the council in,
Yeah.
we have told Mr. James that he can respond further to that when he puts in
Okay.
his final closing submission. So there's been some discussion on it already, and there is still that separate final closing submission for any final observations on that to be put in. So because it doesn't relate specifically to conditions, it's not really for conditions for today.
I agree what you're saying, but to some extent it does, because if there's going to be a noise limit condition for 35 dBA daytime, daytime, and 38 dBA nighttime, the inference would be that that would apply to that particular property as well. Now, the council's position is that there may well need to be higher limits. So it does touch on to the condition session, which is why I just want to flag it up now and suggest that that's I agree, further submissions as has been agreed, but if there are further submissions, it might slip back into the condition, the noise levels for that particular property.
Okay, and the issue of whether that particular property becomes within this same discussion as the ones that are covered has already been covered. So it's not one for reintroducing in the discussion.
Okay.
So
No,
I
that's
know
fine.
your point.
Yeah.
Okay, thank you. Mr. Shepherd.
Thank you. I just wanted to reassure Mr. Grosvenor in respect of that property, because I understand he has concerns over it. It's not included because it's not a residential receptor, but would it to suddenly become a residential receptor before the permission is granted, there's provision within the conditions for limits to apply at that property. So noise limits within the planning condition apply at all properties in the vicinity, even if they're not listed within that table. And so that is set out within part E of the noise condition, which says that the limits from that table are applied at the complainant location, based on the geographical position relative to the properties in the table. So I would just like to reassure you in that respect that if it was now considered as a residential receptor, then it would have noise limits, and would be conditioned. The only other thing I just wanted to come back on in terms of what Mr. Perkins said is just his concern about excess amplitude modulation and sleep disturbance. And just to go back to my original position in terms of the necessity of an AM condition here, we've got predicted operational noise levels of 31 dB LA90. That's 7 dB below the lower nighttime noise limit agreed, and a further 11 dB below the ETSU R97, 43 dB lower limit at night. And so actually operational noise levels are significantly below those permitted within ETSU. And so the likelihood of any significant impact at night and sleep disturbance, with or without any excess AM, I think is very low. And the knock-on of that is, if we add the amplitude modulation penalty onto our predicted noise levels within the EIA, the limits are still met, even if we were to add on the worst case penalty of 5 dB. So there isn't actually any extra provision in there to afford protection to residents if excess amplitude modulation occurred at the predicted noise levels presented within the EIA, because there would be no reason for the operator to then have to bring levels low because the limits would still be met.
Okay, no more hands up. I'll stop looking away so quickly when I say that. It doesn't look like it. No, we'll take a break. We'll come back. We've only really got the nature spot conditions to go, and they're not here, so it probably won't be in Elon. Oh, Mr. Innes.
Can you release the acousticians from? There's not going to be anything at the end that you wish you'd asked, or maybe released from conditioned hearing section.
Yes, I'm happy to release the acousticians. Sounds like something exciting might happen when you say that, would it?
Thank you, Mum.
Okay, and I'll see others back. Let's just take a 10-minute break. Let's come back at 5 to 4 and we'll resume with the Nature Scott conditions. Okay, thank you. who needs to be back? Dennis, Miss Cedric's with you there in the room, is that right? Yeah. So we'll move on to agenda item 3, which is the conditions which haven't been agreed with Nature Scott. There's 3 of these. Nature Scott aren't here and they're happy to go by the wording as to where they've got to, which is set out. They've got their statement, but it's also summarised in the applicant's final schedule of proposed conditions, which is CD 014003. So I'll just start with the first. The first of those is condition 6 on aviation lighting mitigation. Now, from my reading, it looks like the dispute which relates specifically to the wording of the condition rather than the wider discussion which we've had already as part of the LVI inquiry session seems to relate to the wording of the condition and whether that should additionally refer to visual impact mitigation as part of the reason for the condition. So, Mr. Innes, do you want to, if you're still here, which I'm not sure you are?
Oh, he is still here, but it's me on the screen. I haven't been left alone.
Rick, that's all right.
So the question is essentially the reference to landscape and visual in the context of that, and we don't think that it does need to be included. We don't think it's necessary.
Okay. I'm interested in that point because it was discussed quite at length in the landscape and visual impact inquiry session. It was discussed generally there as being necessary as a key part of the applicant's proposed mitigation for the visual impacts of the development that had been identified, particularly the nighttime impacts. And I did ask Mr. Van Hoogstraten when he gave evidence, was, just to clarify, was the purpose of the ADLS scheme primarily aviation safety or lighting or both? And it was both. So apart from they're not.
It's required to reduce the significant effect, but that the reason, as I understand it, is an aviation reason to do it, but it has the benefit of taking away the significant impacts on landscape and visual at night time.
Okay.
But isn't the fact that the reason as it stands currently is, yes, it needs lighting for aviation safety reasons, but it needs the ADLS to mitigate the landscape and visual impacts. You could have the lighting without the ADLS, couldn't you?
Yes, you could.
So isn't there a two prongs to the reason here? That the first part of it is you need the lighting system because they're so high, but you need the second part of that is you need the ADLS because Kelly Anderson's answer to the impact is
yes,
you need this because of the impact on landscape and visual effects at night. So isn't it are there two things there?
Yes, that does make sense when you put it like that. I was sort of thinking of it in the context of the traditional aviation lighting condition. So yes, I think when put like that, it does make sense to include that reason.
We've also included Nature Scott as the consultee. I'm not sure that they would be able to comment that. But as soon as I started discussing the matter with the witness, I was blocked from discussing aviation safety matters in relation to it. So I sort of get the point of, if you've got Nature Scott as a consultee to the discharge of the condition, their interest is not aviation safety. It is in relation to the visual landscape and visual, well, it's more visual, but the visual impact of the measures that are produced within the scheme, and making sure that it matches what effectively they've been told would happen. And I think they definitely need to be in. But I think it would be the interest of aviation safety and visual amenity is probably the better description in its broadest terms. If you're looking at justification, I think visual amenity probably covers it.
Okay. I mean, when you have somebody down as somebody to be consulted when the condition comes in, I think it's generally, views can be taken on when that's necessary, or whether they'd be able to take a view on whether they needed to comment based on the nature of the information that was coming in. Yeah, that was really the basis of our questions on this one. Was you need lighting for aviation safety. The only reason ADLS is being proposed as an alternative to what was described by Mr. Van Hoogstraten as the preferred option of lighting it all is to address the nighttime visual impact, as far as we're concerned. So we've been over that. So your concern now is less the idea of broadening out that reason to cover the that purpose. It's that Nature Scott would be asking to be a consultee to the ORVIMP, but wouldn't necessarily be able to comment on it. Yeah.
Yeah.
Well, they would be if it wasn't adequate. If there was any watering down commitments that have been made, Nature Scott would say that's not what was said, or what was capable of being said. We've obviously indicated we've got a reduced lighting scheme. That all would have to be part of exactly what was set out in the whole scheme of lighting.
Okay. So in terms of, it sounded like a slight change of your position.
I think it's probably nuanced because we then wrote a letter saying that we beefed up the condition a bit afterwards in an additional letter on the 29th of February. But our 29th of February letter didn't really address, and I think that is an omission, the reason for the condition. We only changed wording to incorporate, to make it clearer in relation to the ADRs being operational throughout. And it was trying to allay the concerns of Nature Scott, which may have been around the fact that the Scottish ministers were able to essentially, in writing, permit a change to the scheme. What we wanted to make clear was that's not in a way to stop having an ADLS system operating, because I think that was a concern of Nature Scott. So we wanted to explicitly require that. So, as I say, we beefed it up and recognised Nature Scott's point and added to it. And I think in those circumstances, it is even more appropriate to have visual amenity within the requirements, because that provision is directly being provided to allay Nature Scott's concerns about visual amenity. Thank you.
Okay, thank you very much. I think that's all I've got on the condition. Anything else? The next one on the list, I've got that one twice, but I think we've covered it. Condition 18, construction and environmental management plan. So I'll just turn to that one and I'll ask you, Mr. Innes, or Mr. Drick, to just explain what are the unresolved issues in relation to the wording of this condition with Nature Scott.
So my understanding on that one is that Nature Scott were content that their concerns had been addressed, as the required information would be included in the SEM. And then, although Earraghail and Bute raised a further issue regarding water management, that was agreed with Earraghail and Bute, but we understand that Nature Scott didn't have any concerns about the response to that. So our understanding is that they are content with it.
Okay, and it's not on your list, the Council, of conditions you're disputing. Is that right? That's not something I've missed.
That's correct, ma'am. It's not on our list.
Okay, so we think that one is resolved. The next one is condition 23 on the habitat management plan. Is there still an unresolved point on this one, or has that been agreed with Nature Scott now?
Again, we think that's been agreed, and we note that Nature Scott accepted the edits that were made towards the end of January. And the addition there was in the context of the third paragraph, the HMP shall fully address the mitigation and enhancement measures, and then an addition to the reasons.
Okay. Well, that was a straightforward discussion on that one then. Okay, thanks very much. Are there any other conditions that I've missed that have not been agreed either with the council or Nature Scott?
Not as far as I'm aware.
No, that's fine. And under matter 4, I'd asked in the PEM if parties could consider whether the schedule of conditions was picking up at issues raised in other consultation responses that would ordinarily be resolved through conditions. And Ms. Knox, you included in your hearing statement that you believe you've done a review of those submissions and you're content that they're all covered. Is that right?
That's correct, ma'am.
I believe likewise.
You agree as well. That's great. Do people have anything else that they would like to point out or raise in relation to the schedule of conditions and discussions that have happened on that?
No.
No, thank you.
We've almost not had a break. Okay. So very, very few closing remarks. That's the end of the hearing session on conditions. Thank you to everybody who contributed to that, including the departed noise people. There is one further oral session to take place within this inquiry, and that is an inquiry session on aviation safety. As things stand, that's starting on Monday. It may be delayed. Mr. Innes, you got your hand up, sorry.
I just want to say one thing on behalf of the applicant, to thank the council and their team in terms of the degree of cooperation that was provided in the run-up to the inquiry, both in relation to conditions and policy session. But we did make considerable progress on these matters and really narrowed matters, and that only happens when people take the time and effort to engage. And I just want to say on behalf of the applicants to thank Arlene Knox and her team for doing that, and Mr. Carroll, because as I say, the only reason this is really short is because of the work that was put in. And I know it was time consuming. And just so on behalf of the applicants, we're very grateful for that.
Thank you, Mr. Innes.
Thank you, and I'll note that as well. And we are grateful to people for all of the work that has been done on that as well. So just the aviation safety inquiry session to go. That will either be next week or hopefully very soon after next week. And after that, we'll be moving on to report writing in earnest. So thank you again for your participation. I will release all of you now to follow. Bye bye.
Thank you.
Thank you.
Thank you.